Item number 6, man, I filed an IA today, man. Yesterday. It is in record, I think.
Okay.
It is on supplement. Deeply up.
Responsible there regarding item number 49 of subsequent date.
Huh?
Item number 49 of subsequent date.
49. Yeah.
So can it be taken now after the book of matter? Deeply up.
May please, man.
You inform the other side.
Yes, right.
Have you informed?
I'll inform.
May please, man. The document in item number 38, man. The order category. I appear for the respondent.
Hmm.
On the last occasion, my lord had directed me to obtain instruction as to whether or not that 60-40 payment of deposit will be made by the ONGC or not. I have communicated to them. Now, the concerned law officer, my lord, is attending to a medical emergency, my lord, family emergency. He's in Chennai. So I'm praying for some accommodation. That instruction hasn't come.
That was a case filed by you
No, my lord, we are the respondent.
earlier.
No, this is Ellison Oilfield, my lord, versus the ONGC. They have basically assailed an order of the additional district judge where he granted stay of the arbitral award without requiring the deposit. So my lord had directed me to obtain instruction whether that 100% deposit in the 60-40 ratio will be made on. That I've written to them, I've communicated to them. That instruction hasn't come because he's attending to a family medical emergency in Chennai. I'll place it, my lord. Sometime I'm saying for.
Mr. Counsel, are we out here in a case? This is a case today in this time when you can call up somebody by telephone and get your instructions by email. Is it can it be conceived of that you are still going by the same
No, I've
method by which you write a letter and then it is sent by speed post and then it goes out there and it is for them and the entire ONGC is on that basis? Don't come up with this type of excuses.
I've written to them, I've sent an email.
And if they don't reply, we pass the order. If you don't pass the order, let it be done. The stay cannot be in more particularly in this type of case.
There is an interim order in favor of the petitioners.
For
staying of that award. The 34 proceedings have been stayed. The 34 proceedings that we filed before the learned trial court, they have been stayed by the company.
It is not material. He is entitled to the amount.
That only that instruction. They wait for some time.
We are not staying the 34. Let the 34 go on. We set aside that order. There cannot be a complete stay. And direct the court to proceed with the execution.
And the 34. And the 34 as well.
Well, the court has to do it. The question of granting a stay in these proceedings does not arise. 227, you don't stay.
Only sometime, my lord, I'll get the instruction. I can place it on record. The person is not there.
Not necessary. Is the entire ONGC on the basis of or that person is holding the entire thing about the ONGC in his shoulders?
The matter come up,
huh?
Let me take it up.
Two. Or when it comes.
Whenever.
RSA for? Sorry. Next.
I beg to mention item number 9 and 10. I am praying on behalf of Miss J. Kolita. She could not come due to pregnant.
Item number
9 and 10.
You took adjournment last time. This matters? No. Why? It's a simple MFA.
Lordship, I am not in this case. Lordship, I am praying on behalf of Miss J. Kolita.
What about Mr. BC Das?
She could not come due to pregnant.
BC Das is there.
He is out of.
So we'll put it none appears on behalf of that.
Next week.
Don't have to take adjournment. No adjournment. You will remain present. Want to withdraw? No liberty?
No liberty. Second,
What is this? Second appeal.
second partition suit, my partition.
Huh?
It was a partition suit.
Hmm.
That's the problem.
Mr. A. Iqbal, the learned counsel appearing on behalf of the appellant, submits that his instructions to withdraw the instant second appeal. So accordingly, the instant appeal stands closed on withdrawal, stands dismissed on withdrawal. Full stop. The LCR be returned, any interim order passed and taken.
Thank you. Right, please, Lord.
Yeah.
My lord, the impugn order is at page number 46.
What is that order?
That order is, my lord, that in the midst of the proceeding, my lord, the learned trial court has passed an order stating inter alia or observing inter alia that the written statement filed by the defendant company shall not be looked in.
Shall not be?
Looked in.
Why?
My lord, because there was an allegation that the person who has filed the written statement was not the director in the year 2019. Whereas on the contrary, we have made the this data report, my lord, that he was since 2017 till 2019, that till the date of filing of the written statement, he was the director. My lord, page number 43 is the 46, my lord, that order.
Show me the petition and the what it is.
My lord, that petition is at page number 32, my lord. The petition filed by the plaintiff is at page number 32.
Who received the summons?
The same person, my lord,
Huh?
Anil Agarwal,
No. Who received the summons on behalf of the plaintiff?
on behalf of the defendant, my lord.
On behalf of the.
Yes, Anil Agarwal.
So that means the summons have not been served upon the defendant.
It is served upon that. Lord, I
No.
don't know
If the written statement,
yes,
it is to be construed that the defendant cannot be represented by this Anil Agarwal.
yes,
So if the summons have been served upon that defendant, that person, then it is no service of summons.
then it is no service of. That's what the learned trial court. That's what the learned trial court has concluded.
Prayer was something different, and the order which is passed is something different. Whereas, if your lordship pleases to produce page number 40 and 41, I have also produced the master data from the company registrar, showing that you were the director at that time.
And these certificates which have been enclosed
My
by the defendant, by the plaintiff, are these submitted along with, what are these documents? How did they get it?
from IT, I think. From
Huh?
my lord, from website.
So they download it.
Yes.
So did they put a 65B?
No, my lord. 65.
How is it possible?
My lord, actually regarding first document, we have downloaded from the official website, and regarding
No,
other
no, no.
documents,
Where official website you have done or not, it is a question of proof.
my lord,
How can the
My-
court decide
Rest-
that aspect?
my lord, rest of the data, my lord,
Huh?
we have obtained certified copy from the
Did you produce the certified copy?
Yeah, we have produced certified rest of them.
No, no.
My
Did
lord,
you produce?
we have also obtained, my lord, we have obtained the what is called the annual return submitted by them.
Did you produce those certified copies before the court? I'm
Yes,
asking you that.
Yes. Yes, ma'am.
These certified copies you have produced.
Yes, ma'am. My lord, they do not give it as certified, my lord.
No,
We
no,
have
no, no, no.
applied to it.
I'm
They
asking
have,
you.
they have
No,
supplied.
otherwise you have to, if you have anything, then first of all annual returns, you can get certified copies. There's no quarrel with that. In the MCA website, if you apply for that, you can very well
Yes,
get
right.
those certified
Yeah,
copies. There's
that
no
is from
quarrel.
the website.
Huh?
That is from the website.
Understood.
So, my
But
lord,
if you have downloaded it, would the court have arrived at this position now without the Section 65B certificate?
my lord, but certified copies are there, and my lord, problem is that they have not annexed any of my document, madam. So,
Oh.
let it be fixed on one day. I shall produce all the documents. Whatever documents I have obtained, I can produce all the documents before the court.
No, it's okay.
I-
No, we stay and call for the records of the trial court and see as to it. And the second aspect is, you have not amended your plaint. Why did you make Anil Agarwal a party represented by so and so? And if the service of summons is upon Anil Agarwal, and it has been deemed to have been received on the basis of Anil Agarwal, then the service of summons upon this defendant company is wrong.
That will wrong. If it is that, in that case, there is no service of support.
So then you can't strike
So,
off the
yes.
because striking off of a defense can only happen upon certain applications being filed in that manner. And the court has to be finally said, yes, you can. The CPC mandates certain procedure where you can strike off the defense.
if the
You could have very well asked him some documents making any interrogatories upon him, and if he fails to produce anything, you could have asked for striking off under Order 11 Rule 20. Nothing was done.
that has to be looked into, madam. Whether Anil Agrawal, if Anil Agrawal is chief, then there is no service of law.
We call for the record. To notice. You are the only one?
Yes, ma'am.
Yes, madam. Whole plan.
Heard Mr. A. Sattar, the learned counsel appearing on behalf of the petitioner. Mr. S. Sharma appears on behalf of the respondent. Taking into account the above, you were in caveat.
Yes.
You had filed a caveat.
Okay.
Caveat as in
The MK.
Mr. S. Sharma appears on behalf of the respondent, who is also the caveat. Taking into account the above, the service is deemed to be completed against the respondent. This is an application under Article 227 of the Constitution, challenging the order dated 30/9/2023, whereby the learned court of the Civil Judge number 3, Senior Division number 3, Kamrup Metro at Guwahati, had by the order dated 30/9/2023 had struck off the written statement filed on behalf of the petitioner, the defendant in the said suit, on the ground that the written statement was filed by a person who was not authorized by law on behalf of that particular, on behalf of the petitioner company. This court had perused the said order, and from a perusal of the said order, it reveals that the learned trial court have taken into account various documents, more particularly, which have been stated in Roman 1 to Roman 4 of the said in the impugned order. This court have also inquired with Mr. S. Sharma, the learned counsel appearing on behalf of the caveator, as to whether certified copies of these documents were placed before the learned trial court, or these documents, if downloaded from the website, was accompanied by any certificate under Section 65B of the Indian Evidence Act 1872. The learned counsel, however, submits that these documents were not certified copies. These were not certified copies.
Where regarding the
Are these
I have to
certified copies?
I have to verify. I can check.
Are you not the counsel before?
I am counsel there, my lord. But party has obtained certified copy also and download copy also.
Were these were certified copies?
I have to
Mr.
verify it. I
S.
have to
Sharma
verify it.
submits that he is unaware about that said aspect of the matter and would like to take instructions
Yes,
in that regard. So, taking into account this court also is very this court have also perused the copy of the plaint wherein the petitioner company, which is the defendant in the said suit, have been shown to be represented by Sri Anil Agarwal, who was the very person who had signed the wakalatnama on behalf of the petitioner, on behalf of the defendant, and had also filed the written statement. So the question, however, arises as to whether the said defendant, whether Sri Anil, whether the summons in respect to the suit was served upon Sri Anil Agarwal, and was the summons deemed to have been served upon the defendant by the court, by the learned trial court, on the basis of summons served upon Sri Anil Agarwal. So if that be so, then the striking of the entire of the written statement would not have been proper, taking into account then that the service upon the service of summons upon the defendant would not have been properly served. So taking into account the above, this court finds it relevant to call for the records of title suit number 441/2018 pending in the court of
Civil judge.
the civil judge number 3, Kamrup Metro at Guwahati, who lists the matter again on 26th of June 2024. The registry shall take forthwith steps for calling for the records. This court further stays the further proceedings of title suit number 440, 441.
440.
What is the suit number?
441.
441/2018.
441/2018 till the next. Caveat stand. আগতে ওগুলো special notice needs appeared on behalf. As such, this court is not issuing any formal notice. List for yes, what is this?
This was the petition which was filed against the Land Grabbing Act matter. Judgment of the Land Grabbing Act was converted into Article 227 petition. The judgment you will find it in page 41. It's basically a family dispute. What has happened? The complainant and the respondent number 1, who is the appellant here, are brothers. And the appellant, the complainant had claimed that this land belonged to their father originally, and his father had gifted it to another son, who again gifted it back to the complainant. I am the other brother who he claims I'm trying to grab the land. That is his case. Now,
the brother cannot be a land grabber.
No, it can be. I'm not saying that. So what has happened here is that in this particular case, he initially filed a proceeding under section 144. Now that judgment has not been exhibited. That it was closed, and on the next day he filed this application. Now saying that his brother has been trying to grab the land. The day the case ended, 144 proceeding ended, his brother has been trying to grab the land, and in fact it was filed on the next day. So it was actually after that case was closed, he immediately filed this case, making an allegation that his brother is trying to grab the land. Now there is a report which was called for, the report from the revenue authorities, which shows that no one is in possession of the land. Yet, my lord, the learned court has held him to a land grabber and has directed him to pay compensation for 7 years of dispossession. Holding that he has dispossessed his brother for 7 years, or interfere with the peaceful possession. Paragraph 23, page 51.
Only 1 lakh.
Only 1 lakh, but then
For 7 years.
for 7. Whereas the finding is that no one is in possession. At this juncture, it's worthwhile to point out that the reporter is showing the circle of the
So
Madhya.
you don't want to stay to the judgment.
No.
Now, if the petitioner, the respondent is now being in possession, let it be.
Let it be.
You are not, you say you only want that the tag of land grabber be
Yes,
removed
exactly.
and no further criminal proceedings.
Yes.
So what we do, we call for the record, to notice call for the record and say any further criminal proceedings to be initiated on the basis of.
Right.
I think that is the
Right.
heard Mr. M. Dattodolon counsel appearing on behalf of the petitioner. Issue notice making it returnable by 24th of July 2024. Ms. K. Phukan appears on behalf of the respondent number 1, 2, and 3.
2 and 3, your lord. One is revenue department, your lord.
Revenue doesn't feel like appearing
Yes,
in these matters. You appear for one, these type of
Yes,
matters are there. 1, 2, and 1, 2, and 3. Extra copies of the instant application be served upon her within 3 days. As regards the respondent number 4, steps be taken by way of registered as well as usual. Brother, you know where he stays?
I-
Okay. Mr. M. Datta further submits that he may be permitted to take steps by way of justice rooted to the registry of this court and file an affidavit of service as regards the respondent number 4. Full stop. The petitioner is directed to take steps by way of justice rooted to the registry of this court and file an affidavit of service on or before the next. This court have also taken note of the interim prayer which have been made in the instant application. It has been submitted by the learned counsel appearing on behalf of the petitioner that there is a report being submitted during the course of the proceedings during the course of the land grabbing case number 45/2016 before the learned court below, wherein it was duly mentioned that nobody was in possession of the disputed land. He therefore submits that the question of the petitioner herein being mentioned as found as a land grabber and imposition of any compensation upon the petitioner is completely misconceived. This court, upon hearing the matter, the learned counsel further submits that if the impugned order is not stayed, then the criminal proceedings would be initiated, which may further cause great prejudice to the petitioner. Having heard the learned counsel for the petitioner and Ms. K. Pukan, the learned counsel appearing on behalf of the respondent numbers 1 to 3, this court is the opinion that no further proceedings, opinion that the learned court of the special tribunal land grabbing at Gwalpara shall not further pursue the criminal proceedings as envisaged under the Assam Land Grabbing Act. No? What is that name?
Assam Land Grabbing Act, Prohibition Act 2010.
In pursuance to the order dated 26/4/2022. You are challenging now, or there was some stay? Was there any stay?
No step.
Then what happened till now?
No, there was some delay in approach.
Then, if today you were somewhere in the jail,
No, I'm not in jail. I'm there. I'm outside. I'm not in jail.
you filed the affidavit in 2024. So
Yes,
till then you were there outside. Okay. However, this court makes it clear that the learned court that the impugned order dated 26/4/2022, whereby there is a direction that the respondent herein shall be put in possession of the schedule/suit land is not stayed, and as such, the learned court of the additional district judge Gwalpara, the special tribunal, the court of the special tribunal, land grabbing at Gwalpara, shall take appropriate steps for handing over the possession of the scheduled land to the respondent number 4 herein, that is Mohammad Afsaz Ali.
Obliged.
Record for Poko. The records of 20 people. Yes, what is this?
Here was the petition was prepared application under was order at 7. The summary according to the notice of the defendant appeared and filed an application for seeking assert. That application was rejected. On the next day, the same application was submitted by the defendant. That was also rejected. Then the matter was fit for hearing. Accordingly, the hearing was done. The judgment was passed in favor of the now, after passing the judgment, the defendant prefer an application under order 37 rule 4 for setting aside tax party order.
Then
Lot. In it, subsequently, the state application was allowed. However, the London trial court has overlooked the provision of law. However, since the defendant appeared and filed his Okalatama an application that was rejected, that order was not challenged. That two order was not challenged.
okay. Heard Mr. J. Kolita? You should notice making it returnable by 29th of July 2024. Steps be taken by way of registered as usual within 3 days. This court further calls for the record of summary suit number 3 of 2021 from the Court of the Civil Judge, Junior Division number 3, Kamrup Metro at Guwahati. The registry shall take effect with steps in their regard. What? Proceed for what?
Because the trial court has allowed the defendant to file here the defense. If that is so, if the trial court proceed, then there was like
I call for a record.
in the meantime that cannot be proceeded.
Why? What are they being proceeded if I call for the record of that entire?
Records come.
To go and show that order to the trial court.
Yes.
That will be enough.
Enough.
Records have been called for.
And of like.
Yes, Mr. Jha. What are you challenging?
I'm challenging your worship. I have filed an application under section 47 of the CPC. Challenging
what?
the degree.
Huh?
Challenging the degree, objecting the degree for execution, your lordship, because during pendency of the suit, two of the defendant died, and that degree is passed against the dead.
Against?
Dead person. Dead.
Then?
So, your lordship, if the degree is passed against the dead person, it's another. During the pendency of the suit, no substitution was made. It was awaited at that time itself.
Let's see the plain.
Your lordship. Plaintiff is at case 20, your lordship.
You are the defendant.
I am the defendant.
What is who died?
Defendant number 3 and defendant number 6.
Defendant number 3.
And defendant number 6.
He is
They
son
all are-
of Jumnat Ali. And 6 son of late Tamiz Ali.
They all are from different families.
Huh?
They all are from different families, not from the same family.
What is the decree passed?
Degree passed, your lordship, for recovery of possession, your lordship.
So you are not related.
I am not related.
No. All these defendants are related.
Not related. We all are separate. And here in your lordship, the digital land is the only one schedule.
Huh?
One schedule, indivisible schedule.
Well,
your lordship says
Plaintiff
that
right title, interest and possession and delivery of 4 bighas, 1 katha, 8 lakhs.
your lordship.
You are defendant number 3 and
Seven,
defendant
seven.
number 6. Fattar Khan and Soeb Ali.
Your lordship. I am defendant number 7.
You are who?
I am the defendant number 7 for your lordship.
Who are you?
Who filed the your lordship?
Who are you? Let the legal representatives of those people can only come. Who are you to say this?
Your lordship, if the degree
Law is very
passed-
clear. Absolutely no. That person has to come, the legal representatives, and as such, this decree cannot be done against him. That is the law. 73 Supreme Court.
Your Lordship.
Then
But question is here, Your Lordship.
question
If the
doesn't
decree is
arise.
nullity, whether it can be
No,
executed
no,
even
no,
against me.
no, no, no. Decree is nullity insofar as the dead person.
No, Your Lordship, if the degree is indivisible, then here, Your Lordship, please.
No, individual or divisible.
Then how?
No. First of all, let those people come over and say, look here, we are affected. Let them come over.
Your Lordship,
This is not the
Your
case.
Lordship, I came, Your Lordship, on the ground that the degree is indivisible.
No, whatever may be.
The prayer is before in the plan for recovery of position from all. So if two of person died, Your Lordship, how this degree can be divided now and it can be executed against me? So it's nullity as a whole. And moreover, Your Lordship, please, I want to draw the attention of Your Lordship to the order path. Whether section 47 petition which I have filed, Your Lordship, on the spirit of section 47 petition, my petition was decided.
Did you participate in the proceeding? Sattar Khan and Soeb Ali,
How he participated.
they filed a joint written
statement.
statement. What is their stand?
The same stand which I have taken,
What stand?
that this land is belong to us,
The land belongs to you, all of you, although you are not related.
not related.
Then how does it belong to everybody?
Your Lordship.
No.
This is the stand taken, Your Lordship.
No.
Your Lordship, I want
Let
to
us
come.
see. Let us see how the. And when did you die? Those two persons
Your
died.
Lordship, I have annexed the copies, Your Lordship.
3 and 6. Did you inform the court?
That is
When-
the thing, Your Lordship.
Huh?
Not informed.
Then
But Your Lordship,
who was the lawyer who did not inform?
Your Lordship,
Who was the lawyer who did not inform?
this is the perpetrator, Your Lordship.
Who was the lawyer? It is his fault.
Your Lordship, my
Give me
humble
his
submission-
name.
My humble submission, Your Lordship,
This
please.
decree
please-
cannot
please-
become.
please-
No,
please
you
produce the
can't
plan.
take advantage.
Please produce the plan, Your Lordship.
No,
One thing, Your Lordship, the first title of the plan, page 20. Page 20, Your Lordship.
You did
Whether,
not
even if
inform.
I have not informed,
Page
page 20, Your Lordship.
20 of what?
Plan, the
Ah.
first title.
Ah.
Even if I have not informed,
Ah.
whether the plaintiff was not having a knowledge regarding the date,
Yes.
this, Your Lordship,
Ah.
the address of the plaintiff,
Ah.
village, Kaliajar, Uttar, post
Ah.
office, Sukmarnath, police station, Barpeta, so and so.
Ah.
Same thing, Your Lord, of all the defendants, Your Lordship, in the below, Your Lordship, resident village, Kaliajar, Uttar, post office, Sukmarnath, police station, Barpeta, Moja, Betwari. Same village.
When did the persons die?
Your Lordship, Your Lord, annexure number 5, page 88. Your Lordship, date of death 26/2/16. Thoroughly.
This is some Suravali.
Your Lord.
Name is wrong.
Thoroughly, Your Lordship, like this type of name written. And Your Lordship, next page 89.
Sattar Khan.
Date of death 28/9/2017, Your Lord. Sattar Khan, Your Lord.
Hello, we dismiss your petition.
Your Lordship, my humble submission, Your Lordship.
No.
And I am also on the order, Your Lordship. Whether section 47, Your Lordship, the concept of the spirit of section 47, in fact, dealt by the learned plan. I want to.
Not necessary.
Your Lordship, it is necessary.
Let him go for
because
execution.
if the trial court says that it is nothing with the satisfaction and discharge of the, Your Lordship,
Mr. Jha,
degree,
this matter needs to be finished by 11 o'clock. I give you 2 further minutes to argue for your pleasure. Then I
No,
pass the order.
I am not, Your Lordship, of that, but
And
Your
I
Lordship, my humble
I am
submission,
giving you.
only one
No, Mr. Jha, I give you another 2 plus another 3, 5, and then 2 minutes for the purpose of withdrawing. Yes, which one? You want whichever you feel like. You take it. 2 minutes for arguments and then 5 minutes for dismissal. or
You-
5 minutes
only-
for argument and 2 minutes for dismissal. We do for withdrawing. Either of you choose. Don't lose your time now. Tell me.
Your
It's
Lordship,
always a pleasure of hearing
I-
Mr. Jha, but the thing is,
I will withdraw it, but I want to.
then okay,
You argue 2 points, Your Lordship.
okay. Please argue.
One point, Your Lordship,
Yeah.
whether this degree can be executed against me, if individual degree is there, it cannot. Second, Your Lordship, section 47, the learned trial court deal with the section 47, is saying that it for satisfaction discharge of the degree, it is not required. The death of the person with the doing pendant. Whether that is the right stand, Your Lordship. I want to withdraw it. Mr.
See,
Levi,
there is
Your
one judgment. The legal representatives of these Satali and all, they can very well give them good advice to file
Your
this
Lordship,
40,
Your Lordship,
file a 47, and automatically the indivisible thing will come.
yes, Your Lordship.
But not at the behest of somebody who continued to participate in the trial and did not inform the court.
My humble submission in that, Your Lordship, I may be
Okay,
given, that
Mr.
advice will be given,
and
Your
Judge Learned Counsel appearing on the behalf of the petitioner submits that he may be permitted to withdraw the instant petition. For taking into account the above, the instant petition stands closed.
Your Lordship, but Your Lordship, one observation, Your Lordship, and the legal heirs of the deceased may approach Your Lordship under section 47 or any application.
Wouldn't it show a collusion between you and them?
No, Your Lordship.
No,
No,
if I, no,
No, Your
tell
Lordship.
me, no, Mr.
No,
Jha,
Lordship,
I
it was- it was
I
both,
wanted
Your
to,
Lordship.
I wanted to,
No, Your
but
Lordship.
the thing is, wouldn't that, if I say anything now, wouldn't that show that there is a collusion?
Your Lordship.
I can do one thing. I can do it on, okay. Mr. N. Jha, the Learned Counsel appearing on behalf of the petitioner submits that taking into account that the petitioner herein taking into account that it should have been actually the legal representatives of the defendant number 5 and 6, 3 and 6, who ought to have approached and not the defendant number 7, he would not like to further press the instant petition. So taking into account the above, the instant petition stands closed.
Your Lordship. Multiple. May I please, Your Lordship? Can I ask for the time being, Lordship, because
You are the person
Yes, sir.
who came up out here and said, kindly take it immediately after motion.
Yes, Lordship.
And now you are not here.
Lordship,
This is
there's some legal and
What?
maybe there are
legal.
some legal point that may be clarified by the learned senior counsel.
Fantastic. Let me also clarify with you the ticket will-
In this case,
Lordship.
just after 1 or 2
after 1 or 2 items.
In this case, Lordship, on other day, I did not submit a judgment. It was a judgment of the Justice P.K. Rekha, Lordship, in the point of limitation. In the point of limitation, there has been already that on the judgment is clear, Lord. If there is a delay, that has to be decided.
No. The mistake happened like this. You see, the question of filing an application for condonation of delay is not right.
Right, Lord. You have filed
The
it for
mistake
F1,
all happened because of that.
yes, Lord.
You see, the judgment in Samir Kapoor.
Yes, Lord. I have provided.
Samir Kapoor was followed by another judge.
Yes.
In 2020, 17. This is 2012.
2020.
17 SCC. This is a 3 judges bench.
Yes.
This 3 judges bench was dealing with the question of revocation.
Okay.
Now, they took into account the revocation and said that the date on which the probate is granted, from that date he is, because his right to apply accrues therefrom. But as regards the probate, filing an application for the probate, it is a right in rem, and it is actually not a right which is being sought to be enforced, but it is only a legal recognition. And as such, the 3 judges bench also affirmed the judgment in Samir Kapoor.
Yes, sir.
So under such circumstances, when I gone to and read these two yesterday, I told both of you, Mr. Samaria, that I'll take up this matter. So this is again why the matter. The filing of the condonation was not required. The court can have, but however, liberty will be them to raise all the issues.
A2 may be framed, Lord. In A2 may be framed in this regard, and that has to be decided at hearing, Lord.
Issue, question of filing an application does not arise.
not arise,
It will be
yes.
decided as to whether it has been delayed or not.
Delayed.
Because if you see, there is another judgment of the Supreme Court in 2018. This was also a case for revocation, but there was a delay of around 31 years.
31.
So it says that immediately after getting majority, 3 years thereupon, it was taken. Because at the time when the minor, it was the probate was granted, that okay, after 3 years of becoming major, you should have filed. So, and it was filed in, should have been filed in 1968, but was filed in 1996.
Delay
So
only
there was a
creates
delay of 31.
suspicion, Lord.
Huh?
Delay only creates suspicion. The more the delay, more the suspicion. That is Supreme Court has said in Samir.
Yes.
Lord, they are divergent view, man.
No, there is no divergent view.
Yes, sir.
No, there is no divergent.
I place.
Yes. Yes.
Lordship, this is the Kerala High Court judgment first. The first judgment, Lordship, states with paragraph 27.
No, kindly come to the Supreme Court judge.
Yes, ma'am. Supreme Court, I am coming there. It has been referred. And through citation of Supreme Court, I will place.
You are placing Samir Kapoor?
Yes, ma'am. Yes.
And?
My lord, just look for one paragraph 27.
And this Kunwarjat Singh. Okay.
Case 6.
Tell me.
From the above precedential position, we can deduce that the period of limitation under Article 137 of the Limitation Act applies to an application for probate or letter of admission under the Indian Succession Act, and this period runs from the time the right to apply, which is not necessarily from the date of the testator's death, or the right to apply for probate or letter of administration is a continuing right, and reckoning point is the happening of an event triggering the cause of action a dispute involves legatee's right. It's clear, my lord, no doubt. Now, same view has been adopted in another citation, that is Kolkata High Court.
Now, therefore, that day while dictating, I
Yes,
mentioned it,
quite right.
that if there was a dispute,
Yes, then, my lord, this will come in.
then if there is a dispute,
Exactly, ma'am.
if it has a reason out there,
yes,
for a particular purpose, that okay, my land is there,
yes,
I'm enjoying it, somebody comes and disturbs me,
yes,
and therefore, yeah.
Yes,
but here is the case where he says that he did not know.
Yes. That's why, my lord, then we have to see the citation of, my lord, the other part, my lord, that is Gurjit Singh's Kanpur case.
Yes, let us see, come to that.
That's why I'm coming to, my lord. First, that Samir case, Lordship has already viewed that this Samir Kapoor case, that is clear that it is not counted on the date of the testator. Therefore, not. Now I'm coming to my lord, Gurjit case, my lord. Paragraph 16 is very important. 16.
Of?
Page 31 of my lord, Kanwaljit Singh Kanpur case. Page 32. There are certain principles later on, madam, in reference to the one case, Bombay High Court case. Similarly, reference was made to the decision of the Bombay High Court case in Vasudev Daulatram Sadanand versus Sajni Prem Lalwani case. Rejecting Mr. Dalpatra's contention, I summarize my conclusion thus as follows. Now, B is important. The assumption that under Article 137, the right to apply necessarily accrues on the date of the disease is unwarranted. Now, C is about another thing. Now, Lordship state we come to paragraph 75. It says the conclusion B is not correct. Therefore, it's warranted. While the conclusion C is correct position of law. mean thereby that in such a situation, Lordship, the same position was there. Right to apply accrued on the date of death of the person concerned. It was delayed, therefore, the petition was rejected.
Kindly come to paragraph 14.
Yes, ma'am.
The confusion has arisen because of that paragraph 16 being warranted, unwarranted being mentioned. Kindly come to paragraph 14 of the state judgment.
Article 137 of the Limitation Act reads as follows. Article 130 is a description of application, any other application for which no period of limitation is provided as per the different period of the limitation. 3 years time from which period begins when the right to apply accrues. The crucial expression in the petition is right to apply. In view of what has been stated by the court, Article 137 is clearly applicable to the petition for grant of letter of admission. Rightly observed by the High Court in such proceedings, the application merely seeks recognition from the court to perform a duty because of the nature of the proceeding, the continuing right. The division bench of the Delhi High Court referred to several decisions. One of them was Krishna Swamy so-and-so. In paragraph 17 of the state judgment, it was noted as follows. In a proceeding, or in other words, in an application filed for grant of probate letter of administration, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. Perform probate or letter of administration issued by competent court is a conclusive proof of the legal character of the word. An assessment of the relevant provisions of the Indian Succession Act 1925 does not convey a meaning that by proceeding filed by the grant of probate or letter of administration, no right of the applicant are settled or secured in a legal sense. The author of the testament has passed the duty with regard to the administration of his death, and the applicant for probate of letter of administration only seeks the permission of the court to perform that duty. There is only a seeking of recognition from the court to perform the duty. The duty is only moral and not legal. There is no law which compels the applicant to file the proceeding for probate of letter of administration. With a view to discharge the moral duty, the applicant seeks recognition from the court to perform the duty. It will be legitimate to conclude that the position that the proceeding filed for the grant of probate of letter of administration is not a action in law. Hence, it is very difficult to, and it will not be in order to conclude the proceeding for grant of probate of letter of administration as application coming within the meaning of Article 137 of the Limitation Act. Now, therefore, though the nature of petition has been now this ultimately what happened, what I understood. Suppose there is a dispute between the parties, has already that covered by the case of Tamil. But so far, this, my lord, Tamil's case is concerned, it clearly indicates, or it has again been referred. I have gone through the latest judgment till where the Supreme Court, the last judgment was referred by the Supreme Court in another case, that is Ramesh Nebuti, where the date of death was, my lord, affirmed. Last judgment.
No.
Lordship, kindly seek for a moment.
No, you are referring to that Ravindra Bhatt judgment.
No, yes, madam. Yes.
It did not say that.
Lordship, kindly for a
You
moment.
kindly see what has happened in this case. Let me tell you the fact.
Fine.
One Balaji was married to one lady Anthony. Both were US residents staying out there in California.
Madam.
The will of Balaji say, the will of Antonio say that if I predecease Balaji, Balaji's property, my property will go to Balaji.
Yes.
And if I die, then the property goes to a trust.
Yes, exactly.
Balaji also say that if I predecease, property will go to Anthony.
Yes.
And thereupon what happened after the death of Balaji, the property went to Anthony. There was no problem with
Yes.
it. And moreover, she was the only legal heir. Then Anthony went and got her will probated out there in California on 25/11/1994.
Right.
When they went out there, did it, on the basis of that, they moved an application for letter of administration.
Right.
The one Mr. Patola who moved it initially, he expired and it was substituted by another person. When this very person have done it, then they came to know they got a letter of administration and they go in for mutation.
Yes.
Then this person, the Ramesh, he came over and said that at the time when the mutation was being carried out, we came to know that they have got a probate
in Calip.
in the United States, and they have also got a letter of administration, and as such, it was not proper and all this. So the question which came up before the Supreme Court was only one: whether, in the case of a revocation, whether what is the period of limitation? Because the Indian Succession Act does not say this way or that way. The Supreme Court approved the judgment in Samir Kapoor's case in the case of grant of a probate.
Yes.
Whereas as regards the other case, which is a case of revocation of the
Yes.
probate, it says that as the probate is given is not a right in personam or just a
In
right
rem.
in law, but it is being a right in rem. The day on which the probate is being
granted.
given, that would be deemed to be the date of the knowledge, and from there the right to accrue a
Done.
right. And as such, as it was initially filed in the year 97, notice was issued, which was again withdrawn and again filed in 99. It was held to be parted. So, for the purpose of revocation, also,
Yes.
137 applies. But here the catch point is when the right to apply accrues.
Sure.
Here, for revocation, the right to apply accrues on the date on which the probate is given.
Sure.
Or the letter of administration is given. But on the other hand, for the purpose of probate, it being a moral duty, and there is no right, it is only a recognition of something
Yes.
and not an enforcement of the right.
Right.
It is a continuing thing, and as such, the right to apply accrues on the date when there is a dispute. Now, while going through that, I could get through one judgment. It's a very interesting judgment, on maybe on another point, but this gives a more inner picture of what is right to apply.
Right to apply, my lord, that is there two distinction. The one judgment is there about right to apply and right to, my lord, that fuse, my lord.
Huh?
There distinction between these two nomenclature.
Mm.
One citation is there, my lord.
Where? See, this is 2006 4 SCC 457, the Supreme Court judgment, and more particularly if you come to paragraph number
Yes, I have
22. (21) 22. Article 58 provides that the time will begin from right to run when the right to first accrues.
Yes. That is one of
Article 104 provides that the time will begin to run when the plaintiff is first refused the enjoyment of right. On the other hand, Article 137 uses the word when the right to apply accrues and is similar to Article 113. A suit which is being filed prior to the order of the winding up and pending on the date of winding up gets stayed when an order of winding up is passed. An order of winding up does not create a right to file an application under so-and-so, nor does a right accrue to the plaintiff petitioner in a suit proceeding to file an application under human so-and-so. On the other hand, passing of an order of winding up casts a duty or an obligation on the person who has sued the company to obtain the leave to proceed with the suit or the proceeding. The right to apply for leave accrues not because of the order of winding up, because the suit proceedings is stayed. So it will depend on facts and circumstances of each case. And thereafter, there is another judgment which categorically says that it will depend on facts and circumstances of each case.
yes, but that citation. Facts and circumstances, my lord, that is there.
So the thing is this. We have to, on that aspect, if we go by that,
Then lordship, the dispute is my lord paramount, my lord.
hmm?
Dispute is paramount that when right accrues,
Hmm.
case of apply my lord probate by the suppose that petitioner, then lordship can see that suppose taking that way 2020 the date of notice, no problem. Now, if suppose 2020 is the date of notice, then what attempt he has made otherwise to intimate to the other suppose family members about that existence of, suppose if you disputed, suppose for a moment,
No, not necessary. You see, the moment he knows it, then it becomes his moral obligation in view of the Delhi judgment. And then he can very well file it. Once he files it, then obviously you can very well take the issue, other issues as regards it is fraudulently done, whatever
that
may
is
be, it may be done.
the-
But his right to apply in this case accrued when he came to know. Whether he came to know rightly or wrongly is a question which you may put a question to him at that point of time. However, this question I think will be left open. I should leave it open for the decision in the probate.
On this point, I would like to say one thing.
Hmm.
That suppose date of birth of 2020 the date of. Now, lordship, the test is required, it is sufficient.
Huh?
The test is required sufficient. Now, in that, my lord,
Where is sufficient cause?
my lord, limitation is there. My lord.
Well, how do you bring in limitation?
Well,
Why will limitation come when he came to know only in 2020?
2020 is the date of notice. Thereafter, my lord, he has filed afterward, my lord, not of 2020.
Understood. So from there only his right to apply accrues because he came for the first time to know in the year 2020 and as such he filed on 15/3/2021. So it is within 3 years.
Now, lordship, reason is that, my lord.
In this.
Well, lordship, kindly stay for a moment, lord.
Uh,
It is his own case, sir.
uh.
It is his pleaded case. There is a delay of 1443 days.
He made a mistake. His lawyer made a mistake, not him.
My lord, reason is
They
that,
should have got Mr. D.K. Kolkar then and there.
reason is that, my lord, since he has himself applied the imposed the law of limitation, my lord, once he imposed the law of limitation, my lord, then he has to justify the cause, and their case must be fall within the domain of my lord, sufficient cause, my lord, and that sufficient lordship has already pointed out that source he came to from reliable source. There is no need, my lord, it's a vague statement. Reliable source. Lordship cannot shut down the eyes that that's something which is
So
temporary.
take that benefit of reliable course. Therefore, I put that question open as to whether 137 will apply or not can be very well raised at this stage at that point of time. You can very well raise that issue, which will be open, but there was no requirement for the limitation application.
This opinion has been given in another judgment with Honorable Court of Appeal. That is Bonavatta Sankakoti and another brother Urmila Sankakoti. TRP I have the copy of it. That has been said. It would not be out of place to mention here that issue of point of limitation is a mixed question of law and fact. Evidence is necessary for deciding the same, and as such, the point of limitation, if raised in written objection filed by the person appearing and opposing the grant of probate, an issue that effect would definitely be framed, and that will be decided at the time of hearing, Lord. And limitation is not necessary, not mandatory. Now, Lordship, may I point out one thing. Lordship, suppose take it down that date of knowledge that right from where is right accrued matter. Now, Lordship, for that moment.
No. Normally, for a probate, the right does not accrue from the date of knowledge. No, it does not. It will only accrue when it is necessary for him to do so. Kindly appreciate it. But in this case, when he came to know, he did it, and out of his moral obligation, he went out.
Yes.
So, it is within time.
Yes. Now,
The question of filing an application for limitation did not arise.
Now, Lordship, for a moment, suppose he did not require to file limitation. Take it that way, but that it is within the limitation. Therefore, but the evidence will speak about the story that what thing remains or not remains. Now, question is that, my lord, if we look into the my lord bidding, my lord, if suppose he has designed his own petition, just for a moment, my lord.
I'll say the decision out here shall not affect the trial. Any observations made here shall not.
That is that will become a independent, my lord. Suppose the proceeding that would be initiated. No, Lordship, just look for a moment. Their petitions, my lord.
I've seen the petition. I've learned it by heart.
No trigger. Now, Lordship, what I pray for this moment. On last occasion, Lordship, only the clue is that the date which when that time will start there properly.
You want the earlier draft?
Lordship, if there is a diversion, my lord, my client will Lordship know that he has already gone through the my lord online submission and decision, my lord. It become very my lord critical.
No, whatever maybe. I told you next day because the court can't sign a wrong order, whatever you mean. Because at that point of time, I was of the view, but later on, when I thought that it was not necessary in this case for filing an application under all. In fact, the judgment in the Supreme Court in the case of, and it is continuously being followed also in the case of Chestnut, 2021. Justice Indra Banerjee's judgment, more particularly in paragraph 60 and 61, it says, the section 5 of the Limitation Act even does not say that they would need to file an application. It is
Yes,
for the
Lordship-
court to see.
Lordship already decided 2022 judgment that there is no necessity until the pleadings are all, enough for that to decide the issue.
So now let me dictate in 10 minutes, then I write. This is an application under Article 227 of the Constitution challenging the legality and validity of the order dated 2/5/2023 passed by the learned District Judge Tinsukia in Mizze case number 4/2023, whereby the application for condonation of delay of 1443 days was allowed. Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, drawing the attention of this court to the application so filed under Section 5 of the Limitation Act 1963 by the respondent herein, submitted that the said application is completely vague and does not explain as to why it has taken 7 years for the purpose of filing the application seeking grant of probate. He further submits that there is no materials, there is nothing mentioned in the application as to from what reliable source the respondent herein had got information that his mother had executed a registered deed of will, a registered will on 23 on a registered will. He further submits that the said will on the face of it appears to be suspicious, and taking into account the said purported will appears to be suspicious. The learned counsel, further referring to the judgment of the learned trial court, observed that submitted the learned trial court completely to fail to take into account the well-settled principle under which when a delay can be condoned. The learned counsel submitted that a delay being inordinate, the negligence being self-evident, and the laches on the part of the respondent being apparent, even if there is a sufficient cause shown, the court ought not to have condoned the delay. In that regard, the learned counsel has drawn the attention of this court to the judgment of the Supreme Court rendered in the case of which one?
My lord, I am referring about my lord that Moljit Singh.
Huh?
Moljit Singh, page 30.
Samir Singh?
Samir Singh, my lord, I am
Oh,
relying
yeah.
on
Of the judgment of the Supreme Court in the case of Kunwarjit Singh Kanpur versus
Kirandeep Kaur,
Kirandeep Kaur and
Yes.
others reported in
2008 SCC 463.
2008 8 SCC 463.
Another citation, my lord, Ramesh Nivruti Bhagwat.
Huh?
Another Ramesh Nivruti Bhagwat.
As well as the recent judgment of the Supreme Court in the case of Ramesh Nirvuti Bhagwat
2020.
versus Surendra Manohar Parekar, reported in 2020 17 SCC 284. The said judgments have been placed before this court to support his submissions that the period of limitation in terms with Article 137 of the Limitation Act 1963, for short the Act of 1963, for the purpose of grant of a probate, for the purpose of filing an application for grant of a probate, commences on the death of the testator, isn't it?
Yes.
On the other hand, Mr. D.K. Kolita, the learned counsel appearing on behalf of the respondent, submits that this is a case where there was no necessity of filing an application for condonation of delay. Inasmuch as a reading of Article 137 of the Limitation Act of the Act of 1963 would show that the said act that the period of 3 years has to be reckoned from the date when the applicant, when the right to apply accrues upon the applicant. And in the instant case, it is only when the respondent herein got a copy of the registered deed of a registered will dated registered will
21/11/2013.
huh?
21/11/2013.
21/11/2013 on
Sheet number 56. Came to know on my lord last paragraph 6/10/2020.
6/10/2020.
20. Page 30.
The period of limitation at best could have been reckoned from there. And as the application was filed on 15/3/2021, the same was within the period of limitation. He further submits that a will seeking a probate, that an application for grant of a probate in respect of a will is not a case where a right is sought to be exercised. A right is sought. it is a case where a recognition, a legal recognition is sought to be given to the registered will or the last will of the testator, which is nothing but a moral duty which is imposed upon the executor. Therefore, he submits that unless and until the right to apply did not accrue, the period of limitation would be the right to seek probate of the will would be a continuing right, isn't it? In that regard, the Learned Counsel has referred to the judgment of the Supreme Court in the case of Samir Kapoor versus
State Pro Subdivision Magistrate South New.
reported in 2020 12 SCC
480.
48. I've heard the Learned Counsels appearing on behalf of their respective parties and have given due consideration to the facts, to their respective submission. From a perusal of the application so filed, seeking application being misprobate case number 4/2021. And reading the same with the application under Section 5 of the Limitation Act 1963, it transpires that the respondent herein, who is the applicant, came to learn from some reliable sources that his late mother had left a will thereupon. The respondent herein made an application to the Public Information Officer Tinsukia under the Right to Information Act 2005 and was informed by the communication dated 11/2/2020 about the existence of the will of his mother, which was registered on 21/11/2013 and was supplied a copy to his lawyer, who handed over the same to the respondent herein on 25/9/2020. Thereupon, on 15/3/2021, the said application was filed, being misprobate case number 40/4/2021, along with an application for condonation of delay. This court, for the purpose of deciding the respectful submission, finds it very relevant to take note of that Section 276 of the Indian Succession Act 1925 relates to a petition for probate. Section 263 of the said act relates to revocation or annulment for just cause. It is seen that the Succession Act of 1925 does not prescribe a specific period of limitation for grant of probate or for moving an application for cancellation of a probate or letter of administration. In the case of Kerala SEB okay, SEB versus TP Punha Liuma, reported in 1976 4 SCC 634, the Supreme Court, while distinguishing Article 181 of the Limitation Act 1908 with Article 137 of the Limitation Act 1963, observe that the provisions of Article 1, the limitation prescribed in Article 137 of the Act of 1963 shall be applicable in respect to a petition for grant of letter of administration or for a grant of probate. Thereupon, the Supreme Court in the case of Kunwarjit Singh, Kanpur, Supra, observed that the crucial expression in Article 137 is right to apply, inverted comma, right? It was further observed that an application for grant of letter of administration merely seeks recognition from the court to perform a duty, and because of the nature of the proceedings, it is a continuing right. This court further finds it relevant to take note of another judgment of the Supreme Court in the case of Linete Fernandez versus Garte Matia. Since deceased by legal representatives reported in 2018 1 SCC 271, wherein the question arose as regards the limitation for filing an application for revocation of a grant of a letter of administration. In the same judgment, the Supreme Court observed at paragraph number 19 that one must keep in mind that the grant of probate by a competent court operates as a judgment in rem. And once the probate to the will is granted, then such probate is good not only in respect to the parties to the proceeding, but against the world. It was further observed that if the probate is granted, the same operates from the date of the grant of probate for the purpose of limitation under Article 137 of the Limitation Act in proceedings for revocation of probate. In the said case, taking into account that there was an unexplained delay of 31 years, the Supreme Court held that both the District Court as well as the High Court were justified in rejecting the application for revocation of the grant of probate. The judgment of the Supreme Court in the case of Samir Kapoor, as has been relied upon by Mr. D. Supra, as has been relied upon by Mr. D.K. Kolita, seems to be more apposite into the point involved. Wherein the case involved were twofold. Case involved dealt with two questions. The first question is as to whether Article 137 of the Limitation Act shall be applicable for application for grant of probate or letter of administration. And the second was whether the application under Section 228 of the Succession Act shall be barred by the period of limitation prescribed under 137 of the Limitation Act, and whether the period of limitation for application under Section 228 of the Act would start to run from the date of grant of probate by a court of competent jurisdiction situated beyond the limits of the state, whether within or beyond the limits of India. In regard to the first question, the Supreme Court taking into account the judgments in the case of Kunwarjit Singh Khandapur, Supra, had opined that Article 137 of the Limitation Act duly applied. In respect to the second question, the Supreme Court dealt in with detail as regards Section Article 137. And observe at paragraph 14.1 and 17. As hereinunder. From the above paragraphs so quoted, it would be apparent that when an application for grant of a probate or letter of administration is filed, no right is asserted or claimed by the applicant. The applicant only seeks recognition of the court to perform a duty. It was further observed that a probate or letter of administration issued by a competent court is a conclusive proof of the legal character throughout the world. Further to that, the proceedings filed for grant of probate or letter of administration is not an action in law, but it is an action in rem. It was categorically observed that the right to get the letter of administration is a continuous right which can be exercised at any time as long as the right to do so survives and the object of the trust exists or any part of the trust, if created, remains to be executed. This judgment of the Supreme Court in the case of Samir Kapoor Supra, which was rendered by a 2-judges bench, was affirmed with approval by a 3-judges bench in the case of Ramesh Nivruti Bhagwat Supra, wherein the question involved was particularly as regards revocation of a grant of letter of administration. Therefore, from the above settled position of law as it stands today, an application for grant of probate or letter of administration is for a court's permission to perform a legal duty created by a will or for recognition as a testamentary trustee, and is a continuous right which can be exercised anytime after the death of the deceased, as long as the right to do so survives and the object of the trust exists, or any part of the trust, if created, remains to be executed. In the instant case, it would be seen that the respondent herein had claimed that only on 25/9/2020, the respondent came to learn, have received a copy of the registered will. It would also be seen that on 11/2/2020, the respondent received an information about the existence of the will executed by their mother, which was registered on 21/11/2013. Therefore, the respondent herein who have been made the executor as per the will had a moral duty to seek the legal recognition by filing an application for the grant of probate. The same was done with by the respondent within the period of 3 years from the date of his knowledge. And as such, in the opinion of this court, the question of Section 5 of the Limitation Act, of an application under Section 5 of the Limitation Act, was not at all conceived in the state proceedings. In that view of the matter, when the Section 5 application was not conceived of, the order which had been impugned in the instant proceeding, rightly or wrongly, was not at all required for the purpose of entertaining the applications for the grant of probate. Under such circumstances, this court holds that the order so passed by the learned court of the district judge, or impugned order passed by the learned district judge, was not dated 25/5/2023, was not at all required as per the provisions of the law, and the learned court of the district judge Tinsukia shall entertain the misprobate case number 04/2021. Before parting, this court, however, makes it very clear that the observations so made as regards the will, the will executed by the mother of the respondent, or as regards the date of the knowledge of the respondent in respect of the will, are only for the purpose of adjudication of the instant proceedings, and the same shall not influence the learned trial court, the learned district judge at Tinsukia, while deciding the misprobate case number 4/2021. In addition to that, for the sake of clarity, this court observes that the question of limitation as regards the will can be very well raised, would be available to the petitioner herein to be raised, and the same shall be decided on the basis of the evidence which is produced on record.
From the chief whip.
Page 160. Internal page 6. Here your lordship will find at the last paragraph, clause 3. Here they have stated how they have gone and what they have done. And in page 64, they have clearly mentioned
Page?
page 163. Starts from clause 3, down below your lordship in bold letter. I'll just read that. Before activating a new SIM card, the employee of the licensee who is activating the SIM card shall verify that the details of POI documents submitted by the subscriber are matching with the records available with the licensee, and also record a declaration to the effect on the copy of the POI document under his or her name, designation, signature with date. DOT observation. The declaration of the employee of the licensee is available on the DKYC CAF. However, the correctness of the same is examined as below in reference to the records available with the license. Now, your lordship, the next page, 164, they have given the analysis of details explicitly mentioned on the POI document submitted by the subscriber. The first column says details of POI document, and second is as per submitted of POI, as per records available, observation of DOT, and compliance state. Now, let us, lordship, first part is the name. Name is compliant. Father's name is compliant. Now, the third is photograph. Photograph, your lordship, find at the compliant status, non-compliant, as some of the other identity details mentioned in the POI document do not match with the records available with the licensee as elucidated below. Then, your lordship, date of birth, that also not compliant. Then the next page, your lordship. In the last one, address. As per the DOT instruction, the POA matching has not been mentioned as a requisite step. Hence, a change in address could not be taken as a ground to reject the SIM swap request. Now, final decision. Additionally, the new CF incorrectly lists the gender of the subscriber as male, contrary to the female, as mentioned in the old CF, as well as female mentioned in the associate POI document. This can be attributed to an error on the part of the data entry by POS. It was also overlooked by the activation officer of PSP while matching two documents. Overall compliance status, non-compliant. So, your lordship, they have found that it is not compliant. And page 166, they have given the summary, the compliance status. Based on the preceding analysis, the overall status of compliance with the licensee of DOT instructions dated so and so per se in the instant case can be marked as non-compliant on the basis of the DOT observation. So, here now they have clarified that it has not been complied. The with regard to date of birth, photo, and the other details have not been complied with by them according to the DOT instruction. Then they have also given a SIM chip replacement at page 167 under the DOT revised instruction. But that instructions came in 2023. So I don't know how far that will be applicable here at page 167. So here they say
This happened in 2020.
20.
And what is this 169?
169
9.
is your lordship the communication by DOT to for alternate digital KYC, how to activate digital KYC here. Here
For
mainly,
new
mainly
mobile
it
cards.
is with regard to new customers.
We are not.
Here nothing specific except at page 170 there is a M. The authorized representative of licensee shall check and verify that information available in pictures of the document is matching with the information extracted by POS. It is page 170, serial M. That's the only thing he has been given here. Is with regard to new connection name. Here they have stated that now they have to take live photo. So how they will correlate, that has been. So here also the same thing is said that it has to be matching with the origin. This is basically the KYC process, and the next one is 31/8/2023 170. This is another notification. Here, your lordship, the
Yes,
And-
Mr. Das, what is this IA
Yes,
for?
My lord,
What is this IA for?
Yes. Just I will tell your lordship why the dot was required. Because we also know apparently at page 98 and 101 it didn't match. Yes, but your lordship has to see doubly sure that what the procedure which has been laid down. Now today, the procedure is before the court saying that no POI should match. Apparently POI doesn't. And this we can improve. That first day also I told your lordship. Now, this I went and I verified entire documents again. 2-3 things are important, subject to your lordship allowing it, because your lordship into a bigger issue of the particular how the SIM step, how this fraud has taken place. Lot of fraud has taken place all over India because of maybe of say SIM or for what purpose. Now, my lord, 2-3 things are important. What IA is for. Three particular things which we have prayed for. One is, my lord, if you see the particular the SIM which applied 1/10/2020, about 345 that application has been made. It has been lost. It takes then back office, my lord, has verified this particular document and ultimate SIM was handed over. Now, as per information of the Airtel, it takes about 2 to 3 hours to get an activate of the SIM. You may not receive an SMS. Terms and conditions says that if it is a postpaid, 24 hours. If it is prepaid, it takes 48 hours to get an activate. But the issue here, that once you go, a fraudster go and apply the SIM, that it had got lost. One type of message comes to the original SIM holder which is holding. That your SIM, you made an application, your SIM has been lost. Now there is an application has been filed for another replacement of SIM.
Did you send it?
This was sent.
No, this was sent.
This was sent.
How do I know?
No, that's what I'm saying. That's only your lordship will find in the investigation which has been done by the investigating agency. One, because the CDR was collected, all the records are before the investigating agency. These are internal matters where we can't disclose it. It is with the police. Now, very interesting. 1/10/2020, if it gets deactivated. Now, if you see at page 28, there is an information they had made an FIR before the police. Now, in that, I have seen the English version, English translation. If you read the SMEs, that's something else. On 2/10/2020, the informant has received a call on 2/10/2020 about her PLI. that is their life insurance he had received, and some information over phone. Now, I asked my client, how can one receive an over phone? Because if the original phone, the SIM gets activated, automatically it gets deactivated. So somewhere some wrong is there. Then said that all this collection of this data, CDR is with the investigation. So once you'll come to know how it has been done. Now, second, my lord, the ATM. The ATM card, my lord, physically ATM card, some 20,000 was withdrawn on 2/10/2020. 1/10/2020, that's some 9,500. 5,000 is UPA. And second, an ATM, which withdrawal is the ATM card, where, my lord, 20,000 has been withdrawn. All these are silent from the SBI side. Now we are asking, I don't know, my lord, we are asking an IA, some specific direction, my lord. If your lordship kindly see
What
the
are you
IA.
asking for?
Yes, my lord will kindly see the IA. Page 19 kindly be seen of IA 1517 of 2024. Copy. I have served the copy other side of. Yes, okay. This, my lord, will be on a seal cover. We don't know before 1/10/2020 how it was maintained. Because if the SBI life insurance, as per their statement, is 29/10, 29/10, this particular, it get matured, and that's the date. So how it can be before that on 3/10? Page 1920, my.
To page 101.
101 of the writ petition, my lord. 101. 101. I've got it.
Now, this SIM swap submitted at 1/10/2020 at 15:41 hours.
Yes, right.
And
It got
the again a SIM swap submitted at
Yeah.
104 on 4/10/2020
to the daughter.
by the
Again,
actual daughter.
original.
Okay, 4/10.
Yeah.
Now, kindly come to page 45.
45. Yes, 45, I got it. 45.
These ATM withdrawals,
Yes,
1, 2,
it's
on
number 3.
210 and 310,
310.
there are
Yes,
2 ATM withdrawals.
correct. My lord, first ATM, there is no quarrel. They said that they have gone and ATM withdrawal was done. The fraud started from 210 from UPI 5,000. 5,000 the fraud started. That's the statement. There is no quarrel of 9,500. Number
Now, when
20,
was this SIM activated?
SIM activated as per this is at 7/7/30. It was activated on 1/10/2020.
110.
110.
No, but the message, you were able to get the messages
If you
what
see
time?
101, that's written. On the right side, kindly see 101, my lord, page 101. Unpal is right side.
Hmm. Yes.
Yes.
What is there?
That's, my lord, it's a declaration of data entry agent on the right hand side. If you see second column, declaration of data entry agent, date you see kindly, validated by so and so, validated verification date and time 1/10/2020 is 1925.57.
Where?
And my lord, I will tell you one thing, my lord. Watch I got my
No, this is the data entry.
no, that's not the
But
message.
when did you activate
No, that's what I'm telling.
SMS?
From the date, from the time which you apply, then it within 2 hours, thereafter, that particular the 2 hours, you get that particular information. 2 hours.
What?
2 hours. The message, the original SIM card holder will get a message from the Airtel that this has happened. Somebody has applied. A SIM has been applied. So this is a message come to the original SIM holder. That means the lady or the father. So once that message comes in, then automatically
How do I know?
that the all the investigation.
No. Where is your details? Where is your procedure stipulated that after that you are going to send a message to them?
Yes, I'm sorry.
Where is it stated in any of your protocols which you have enclosed that immediately thereafter you will send a message to the owner as to whether you have done or not?
That particular, my lord.
If you have not done
no,
that, then
this all
why
this
should
has come. I am holding it. I got all the instruction from the client, my lord. If necessary,
you are
my lord,
instructed
I
for
don't
this.
mind, my lord.
No, you are asking a particular thing on the basis of a premises that we have sent a message. But where is the necessity for you to send the message for the first time? Because that is not the protocol which is otherwise there.
That's the policy of the Airtel. Because only for
How do I know?
No, that's what I have to come.
It is in hidden somewhere.
No, I'm not hidden, my lord.
Then?
This is when the instructions are being taken.
No,
Then
instruction is okay, but no, kindly see page 137.
Yes.
The person at the POS shall match the copy of the POI submitted by the subscriber with the original and also record a declaration on it along with his name, POS, so and so containing, and he has seen the subscriber match the POS with the original. Only after this activity, new SIM card shall be issued to the subscriber. Before activating the new SIM card, the employee of the licensee who is activating the new SIM card shall verify the details of the POI documents submitted by the subscriber are matching with the records available with so and so to the effect that the POI and designation, name and signature with the date. Where is it mentioned in any of it that there is a requirement that you are going to send a message to them?
That we can, my lord, there is
neither this document at page 101 shows that you send a message.
That's not because that's why I'm asking for the entire CDR, which is before the investigation agency.
Why?
No, CDR.
First of all, why should I go to do the CDR first unless you show that it is a requirement that you do so? I know why you are saying. You say that the moment it is so, then he would have definitely known that there is a SIM swap which have been started, and as such, he should have been more diligent. I know that this is the reason, but where is it mentioned in your detail that this is the requirement that you do follow this protocol?
No, I can come up with that. If that be the case, I can come because you see, my lord,
so unless you don't do that, no, Mr. Das, unless you don't do that, why should I presuppose that you do that you follow those protocols? No. Because that is not the requirement of the 2016. Then,
my lord, that's I can produce the company policy if your lordship want to see that. Because my lord, let me very honest to it. I have gone through it. POI, there is a negligent part, but POI there is a negligent on our part. But my lord, who is the beneficiary? Most beneficiary is the Quicksilver. Quicksilver.
You see, today, you see, Mr. Das, why this matter, Airtel is now being cornered only for one reason. There's no doubt that the petitioner would be entitled to get the money from State Bank. But the problem arises if it was the fault of Airtel. If the State Bank has to pay, then obviously all part of it has to pay. Then under such circumstances, the Airtel has also to bear the burden.
So
That
that's
is
a-
the
that's
reason
a-
why we have
that's
brought
a-
in
I
the
know-
state
I know.
level.
Yeah, I read your lordship mind that day itself, my lord. Only what I am concerned is, my lord, will kindly see other aspect. Your lordship is kindly, my lord. I'll just request your lordship. I don't know, my lord. Your lordship may not agree to it because these type of things are happening. Or your lordship is aware. We are also this time. SIM swap is not only some beneficiary, my lord, is taking the advantage out of it. Some fraudster is taking the advantage out of it. Now, kindly see.
In fact, interestingly, if
Yes.
I'm his voter ID, Mr. Manan, was shocked. That day I was just looking at it. Nowadays you can very well get your voter ID or the details in your, just if you want to go for a voting, there's an application of the electoral.
All the names.
This voter ID, if I put it, is still in existence. The fake one.
It's still in existence in voter ID.
It is still there. It is not a fake one.
So that is.
It is still available in the Election Commission of India website.
And the address and all your lord.
Whatever is mentioned out here is exactly available there. Just for example, just before your vote, you must have got an application from ECI that if you want to see where you have to vote and all, you can very well put that. If you put the said on the said application, this number, which is number is here, na? There's a number out here, election ID number. This is there.
Yeah.
Some number is there. You put that, you get it.
That number, your lordship.
This
yes.
application number, this JX.
JXG.
You put this, you still find out that this lady's phone number, everything is there exact.
And then the name?
Absolutely. It is as this it is. Which means there might be another person of the same name, having the same father's name, in some other area, within the same Rongya area. This person may be there very much.
Maybe.
Because if you see this voter's ID is there. Either maybe it's a fake voter ID made and the ECI have not taken recognizance to this, that it is fake.
In fact, the police have filed their affidavit. In the affidavit, they have stated this to be fake.
It can't be
they
fake.
Found some fake election card.
No, this can't be fake because if it is still in the website of the ECI, it cannot be fake.
Something that part you know, basically it was the duty of the police to find out. They said that yes, we have.
I was shocked when I just wanted to see because that day I got a message just the last time when it came before just the election.
Yeah.
13-5 now. We had our elections on 1-5. Somewhere
7-5.
Yeah.
7-5.
No, 13-5 the matter came here. Nah?
Yes.
Yes.
So 13-5 or something like that. So at that point, we had our elections when 7-5. 7-5. So immediately thereafter this matter came, I was just checking out. If I let come over, I was just checking out. So then I could see, I just entered. I wanted to see mine, so I was just entered. If this is there, this is available in the website of ECI.
I'm going by whatever has been given by the police. They said that they have received the fake ID of the concerned person from the that because they have filed an affidavit. Apparently, it is there.
No, they may get another fake one.
Yes.
But they have not cancelled it. The ECI have not cancelled.
No, they have not. May not.
But if your lordship against is 45, only I was just wondering how they can add this beneficiary Quicksilver. My lord will kindly see 45, page 45. Kindly see 45, my lord, of my read petition.
Of your?
Of my read petition, 45. Page 45, which your lordship has indicated. 45.
Of the writ.
Of the read petition.
Yes.
see kindly after this withdrawal, ATM withdrawal, thereafter, my lord, all this transaction, about I think 9-10 transaction went to
You
quick.
did the ATM withdrawal?
No, first 9,500 was done by me.
Hmm.
That was the first one. Then after that, the UPI and all the withdrawals not done. Except there was a transfer. I think there was a transfer of
SBI life insurance
life.
premium. Life
There's
premium.
one transfer of life
After
insurance
this-
in between. That was done
Which
from
one?
my account.
After 20,000, my lord, at page 45, if your lordship kindly see 45,
There's a
ATM withdrawal 20,000, thereafter WDL, SBI life R&M.
17,966.
No, this must have happened from the bank direct.
Yes,
This
correct.
is from
Direct debit.
from the
But
account.
what is the only problem? It was due on 29. He says that it was 29/10/2020. If it was due on 29/10/2020, it was 3/10/2020. Normally, my lord, due date on the last due date, it get directly it get. How it got on 3/10? 3/10/2020. Kindly see, my lord. 3/10/2020.
This was a direct transfer.
No. The last, you see, they do it 1 month before. You see, when you pay a life insurance or anything out there, they calculate it from a particular date. It becomes due 1 month before. Because you can't pay it
But-
after the period is over.
But if your lordship kindly see at page 13 of para 9 of the pleading, I kindly see.
If it is 29/10
Yes.
is the date, so you see 39 must have been a bank holiday or something to that effect. 39 would be a bank holiday or something. First is must have been
September 30th is
closed.
a bank.
Second is closed. That is why on third it got
So,
struck.
my lord, what has happened? Your lordship, if you see, on 2/10/2020, when this they filed an FIR on 2/10/2000 on that particular date. After that, they made a specific category statement. 2/10/2020, a phone call received. Kindly see the assemblies version. Kindly see the assemblies at page 38. 20, sorry, is 20, 30, 28. 28, my lord will kindly see.
42.
No, 28. 28. Also got it?
Yes.
First, second, ইয়ার আগতে 2/10/2020 তাৰিখে মোৰ মোবাইল নাম্বাৰত PIL কিবা পইচা পাম বুলি ফোন আহিছিল। 2/10/2020 তাৰিখে মই ৰিচাৰ্জ কৰাৰ পিছত 4/10/2020 তাৰিখলৈ কোনো ধৰণৰ ফোন অহা নাছিল। 2/10/2020 লৈকে মোৰ অমুক টকা it went off. So on 2/10/2020, a phone call was received. So I don't know, that means maybe some disclosure of, that's what we don't know, but it appears. If all these accounts details was compromised, well,
No, it may not be
no,
this phone.
no,
It
just-
may be some other phone.
34.
Mainly your lordship.
No,
Two things. My case was on two. First, the account, they have applied for a SIM, right? The fraudster applied for a SIM on 1/10. Let us take the date as 1/10. And on 4/10, when I came to take my amount, some amount, I came to know that nothing was there, about 64 remain. In between from 2/10 to 4/10, these 2 days, they have siphoned off the whole. In whichever Quicksilver XYZ, we are not touched. We have given an FIR as per the law, as per the rules. I have filed the FIR, I have given a complaint before the SBI. Now the SBI has their rules in such cases. The Airtel also has their own the rules and regulations as part of these two are basically our case is my case. That I have not done it. This was somehow the fraud. Now second part, what has the police done? The police has made inquiry, arrested XYZ persons. These are the persons. They found that yes, they have done it. They have done it by doing swapping the SIM, by swapping the SIM on so and so date, and the SIM swapping was done. And after that, all the transfers were made through that. This is basically the whole case. Now what happened? Now after the SIM swapping was done on first of the month, so by the time it has been activated, I have taken out an amount of 9,500. Thereafter, I have not taken any, and in between a transfer has gone from SBI for LIC. Nothing else. Now, what phone I have got earlier was a different matter. Now, that is a issue police will decide. Now, the question is whether the SBI has followed the rules and whether the Airtel has followed the rules of law. These two things, your lordship, has come before you. SBI has their rules. They say that if we are not guilty, if the person is also not guilty, he is entitled to this. I am claiming that. Now, the second part comes when your lordship says the DOT regulations. The DOT regulations are directly violated, and the DOT has come up with the affidavit saying that this has been violated. Now, the question is, if that has been violated, now where the money has gone, which silver, X, Y, Z, that is not the point. What the police is supposed to do, they have taken the documents, they will will arrest the person, whatever his conviction is done, whatever that is.
No, no, Mr. Manan, Mr. Manan,
there.
kindly listen. There's no quarrel with that. The question is only to the effect, give me an idea how to get the money from whom? Tell me that.
That is from the bank. That is from the bank. That day I simply said
Now
that
you
as per
say
the
that
rules,
you
I am
have to
entitled.
get it from the bank. Now, what is the bank going to do if it is the fault of the Airtel
Yes,
as it is
that
apparent?
is where your lordship on the next that day has pointed out, yes, because if it is the fault of the air, then entitled to compensation. Now your lordship has said that since the bank is entitled to pay the air and the fault is on somebody else, it is the bank who can take the money from air, whichever amount has been given to me. For example, I am paid 9. Now Airtel is supposed to pay that 9 lakhs because
So
you
give
have
me,
not done it correct.
give me a solution on that.
That's the only thing.
No, give me a solution. How do I take care of the bank's interest? I'm going to take care of your interest. Give me a solution for that. You give me a solution that you get the order tomorrow or today. Give me a solution how. I already got you the
Yes.
deal.
Yes.
Earlier, this court was not inclined to entertain this, saying that if the money has already gone, you file whatever maybe you get to it. But the fact, after looking into all these things, I said that okay, you are entitled to the money in view of the
Yes,
bank's
by
Reserve
the
Bank circular.
RBI guidelines.
But the fact also remains that Reserve Bank is also, the State Bank is also a public entity. It is public money. Now, for the fault of it, should the State Bank be penalized? Yes, they can recover. They may have to go to try or whatever maybe they may have to do it. That is why I brought in the DOT, and now the DOT has come up and said that they have not complied. Now, therefore, it's their responsibility. They have made that mistake. Now, how do I address the issue? I'll directly to pay you. Then what happens next? How do I take care of the second issue?
Second part with regard to the they are entitled
Bank for me.
as per I think that
How?
TRAI
How?
guideline.
Now, give me that link. How? Give me a
That
link.
day I think I said with regard to the compensation, the TRAI can face impose compensation of the air for violating the norms. That is I think I have.
So you mean to say,
Yes.
we direct the State Bank to make the payment to you?
No, the State Bank will go to TRAI. Yes.
No, that will go. First, the State Bank to make the payment. And then, in view of these materials, let the TRAI decide as to whether the Airtel should be penalized and made payment to the state.
That there is a I think
How do I,
whether I have
the
written that.
second part, how do I fix the doc? Give me that. I'm only on that.
Because they have somebody will have to approach the TRAI. Either the State Bank will have to approach or I have to approach. Normally I do not have.
You don't need to. But the fact that it is a fault, which is apparent now on the basis of the DOT's activity. So under such circumstances, the only problem is how do I take care of the second part? That is the first part is okay. Because if I don't, if there is slight mistake on the second, your first part becomes also affected with the state.
Yes.
But tomorrow, if now your lordship, second part was the
So
major
here,
part.
your lordship.
I'll just address your
Just
lordship.
for a moment, just one, your lordship, just I would like to point out, this is the Information Technology Amendment Act that I pointed out in Amendment 20, where Section 43A of the original act has been amended by inserting a section where compensation for failure to protect data was given. Here, this part is the compensation.
Information Technology Act,
Is the amendment
which one?
2008. I can give this.
I got
I think I have given a copy of on that.
This is
I
very-
think it said there is a limit of 25,000.
Huh?
So we'll just see it. What is limit?
That is there one thing. I'm not very conversant as of now, but I think there was some kind of
the Information Technology Act.
here with regard to corporate, body corporate, possessing, dealing or handling any sensitive data or information in a computer source. It owns, controls, or operates with negligence in implementing and maintaining reasonable security practices, thereby causes wrongful loss or wrongful gain to any person. Such body corporate shall be liable to damages by way of compensation to the person. So there is one part there, 43A, that has been inserted, the new section. I can hand over this.
43A is omitted. By Data Protection Act, it has been omitted. Kindly see 43A.
Digital data.
Yes, digital data. It's omitted. 43A. In
You're referring
2023,
to which one?
is referring
43A, 22, 3 and 20.
There are 40 corporate. Now, this has been removed by the Data Protection Act. 43A is not there.
not
When it has been,
the 2023, man. Act of 2023.
এই আর নতুন এখন আছে নি?
This is new, my lord, I think. It is 23. I got 23.
No, I know that act came only in 2023.
23. Take on.
Now, why it is so? There's a reason why it has been deleted. Because now the compensation is available under the digital. Yeah. Data Protection Act, this is being done because the Data Protection Act, which is there you
There
get
that is
compensation.
so.
And in fact, if they use, not only that, the persons who are there can also be sent to prison. See that? Because that day I was looking into that act for some other map.
the protection act, I have
Because now in view of the Data Protection Act, there is a requirement, there is a certain reference out there in view of the new Evidence Act, which is coming up on 1/7. Now, a lot of things have to be now taken note of with the Digital Data Protection Act. Now, this Digital Data Protection Act, though omits 43A, but gives you better avenues out in that 2023 Act. Now you can very well, there is a particular forum by which you can very well go out there and say that these people have used it. Now, in fact, just for example, Data Protection Act has so much of protection. Just for example, tomorrow you go to a particular shop and go out there and they ask you your number. With that number, they can't send you a message. But if you tell him that, you see, I need a message as to when is this particular good is going to be available, then only they can send it to you. They can't use your mobile number for that. These are various protections which are being given by the digital data. We have it again on 28th, Mr.
28th.
Manan, 28th. On that day, you just find out, and on that day, I'll dictate the judgment in the court. Only find out
Next
how.
part.
Only find out the dots. How do I connect this? Once I connect the other parts, there's no problem. Asking the state bank to pay this, this court is good. There's no doubt. But I'm only thinking, how do I protect state bank so that Airtel can be roped in? And now with the dot, I can. They have made a mistake. Now, under such circumstances, the next question is, if I do it, can I further impose in view of the Data Protection Act also?
Only one thing, your
I
lordship,
haven't seen.
my lord, only one thing,
Hmm.
your lordship, that IA may be taken into account by your lordship. Whatever order passed while
Which one?
dictating the
IA?
IA.
You are asking for a particular document without filing the protocol.
No, not that, not only that, my lord. There are other things
You are
also.
not asking for anything else.
No, we have sought for. We have
What you are asking for? I've seen the prayer. See,
Prayer, kindly see the prayer.
Yeah.
Kindly see the prayer, my lord.
Yes.
Page 19, my lord. The
Mm.
pending disposal, this honorable court is pleased to direct so and to produce the bank statement per period, so and so, so and so. Now, that pending the hearing and final disposal, this
why do you need the period from
Why?
1/4 to
Because I'm giving answer.
why?
So previous, now the period which has been mentioned is 110 to the period which the fraud has taken place. Prior to that, what is the mode, how it was done, whether UPI was done, whether all it will reflect. I am not entitled, I am not privy. The SBI, at least your lordship SBI can give the seal cover to look into it, at least for 2-3 months prior to that. What was the way? How the ATM, how it was paid. That's only. Premium was paid. And my lord, your lordship is looking into all angles because lordship thinking aloud also.
No,
So that-
understood. But why do you need it from 1/4/2019 when the issue is very
No, that's
specific
true.
as to where? Here is a case where they have categorically mentioned that earlier there was no internet apply to the internet password banking was never done by them. They have
SBI filed the
categorically
affidavit.
stated out there.
So no, I am not talking. Internet banking is something else, my lord. Internet
Because
banking.
this happened because of internet
No,
banking.
no, there is not only internet banking.
There are
UPI.
two
UPI, whether UPI was done earlier or not, that's very important. That's only what they have to produce it, whether UPI was done or not earlier.
We are
Your
not
lordship,
concerned.
This is
We are not concerned with the UPI. We are only concerned with this withdrawal which is being done through internet. That is the issue
there
which
are-
have been going on all
the
along.
fraudster is not only to internet. Fraudster is from the UPI also, the ATM withdrawal, all the fraudster, not only to the extent. Now, my lord will kindly see why we are
No,
seeking.
Mr. Das, I am not going to make this a court for you to get documents for your purpose of any evidence in any proceeding. No,
No, that's
nothing
not
to-
there. No, I am not asking for any purpose.
You have to keep good
But kindly
reasons
see
for
the
that.
B. Kindly see B. That pending and hearing, this honorable pleased to direct so and so to produce the SMS DLR report in respect of petitioner bank account for the pay into a detail of SMS OTP sent for the purpose of adding Quicksilver Solution Private as a beneficiary, pay of the purpose of internet banking. My lord, somebody, a fraudster, adding, he is a beneficiary, my lord, and 14 transaction has been done. Out of 14, my lord, as far as my knowledge, my lord, 24 hours it takes a time to add a beneficiary. So how
Huh?
this
What?
24 hours it takes a particular to add a beneficiary.
What?
So net banking, my lord. It
No.
is not done within 1 or 2 hours, my lord.
No.
That's my knowledge. That's my knowledge, my lord. I don't know. That's my knowledge about it. If it is more than 5 lakh
Does
transaction,
does it require in the state bank more than 1 hour?
there is an upper limit, my lord.
No. How much time does it take for? Huh? 1 hour.
But if it is an upper limit of 5 lakhs, I
There
can
is
show
no
it.
5 lakh,
That
all 1 lakh, 1.1
no, no,
lakh,
it's a
no 5 lakh.
total within that
No, no,
period.
no. You
My lord,
cannot have a total
my lord.
transaction. No.
My lord, Quicksilver is a main and their office is there. And they have done all these mischievous things. It went. Kindly see at page 23, my lord. I have given details of this company. Master data of this company. See 23, my lord. I have given all the details of this company.
For what purpose?
This is a company which is a exist and is the beneficiary of all this amount. Kindly see, my lord, 25 this is a review of this company.
Have these people been arrested?
No.
Any of these? Any of the directors, company secretaries arrested?
No, nobody has.
Why?
This is the whole.
If the amount has gone the amount gone to the Quicksilver's account?
They have not
As per
frozen
the-
that account.
As per
Quicksilver-
the, I think bank statement, it went to
Quicksilver's account.
most of the.
Yes, all Quicksilver. No, it's
I
reflected.
think most.
Or 11, 12, it went to Quicksilver account. And today also, my lord, there is no investigation by the police. Neither 41A notice has been given. To Quicksilver, the investigating agency, they are keeping quiet. And a detail. See kindly 24, the bank account of Quicksilver, my lord. 24. Bank account of Quicksilver. See kindly, my lord, 24 of the bank account of the
Page-
Quicksilver. Page 24 of my of IA. Kindly see IA. $24, my lord. These are the bank account of the Quicksilver. Axis Bank, Kotak Mahindra, all these bank account.
No. Let us see what is that. Where is the government's affidavit?
I think page 53.
Uh-huh.
Para
No, kindly come to page 7,
Page
page 54,
54, para 7.
para 7.
Yes. That we
The
did not
amount
put a-
does not go to Quicksilver.
No.
It has gone to these two accounts
And-
of
My
storage.
lord will kindly see. This is what the account, how it gone to Quicksilver, it has gone. Kindly see, my lord. It doesn't go. Kindly see. Bank statement shows. I made a statement out of it. Kindly, the bank statement shows, my lord. Page 45, it will reveal, my lord. I made a chart of it for the convenience. Kindly turn to next page, my lord. So, lordship, kindly turn to next page. Para 7, my lord, they are the accused in the FIR. Para 7 of the affidavit. Page 54.
Hmm?
Page 54, your lordship is reading
Hmm.
page 54, para 7. They are the accused, my lord, of the in the FIR. But the beneficiary of all this money has gone to Quicksilver. And till today, the Quicksilver, no investigation has been done. My lord, see the kindly, I'll trouble your lordship at page 60. Kindly see the bank affidavit. Kindly see and 60. They have admitted, my lord, page 60.
Hmm?
Page 60, kindly we see the bank affidavit. They have admitted that it went to Quicksilver. Kindly see. First, my lord, ending of this paragraph from the bottom 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10, 11. The petitioner, lordship got it?
Hmm.
The petitioner internet bank credential were compromised as a result of 9 of fraudulent transaction was taken place. There is no fault on part. The fraud reported to the concerned branch on 9/10. All the frauds were merchant-based transaction where the funds were remitted to a merchant Quicksilver solution, a third
No,
party.
this Quicksilver solutions is different. You see the spelling. This is QUICKSILVER. Whereas the document which you are enclosing to your page 24.
There's a typo.
No, there's no typo.
No, page 45, kindly see.
No,
45.
page 23, if you
No,
see.
I kindly see 45. 45, man. Page 45. Kindly see 45. Quicksilver solution. The spelling. which matches with our, that's page 45, it matches with page 45, my lord.
Where? In your affidavit. In your affidavit, the typing mistake is there. Now, tell me, you have put this INB Quicksilver solute. SOLUT in this thing. What is the account number in which it has gone? You can very well find out. Statement doesn't say which account number. Or it is the account number. Account number is given 4595721620093.
If that is the account number, your lordship, there are different accounts.
This is UTI number, my.
No.
There are different account numbers in.
No, kindly see 310, page 45.
Yes.
310. The
310.
first one is 93, second one is 93,
Third one is
third
91.
is 91, fourth one is 93,
Fifth is 98.
fifth one is 98,
Then all are
then
different.
sixth
Your lordship.
one is 96, then 96,
No, but that is number is
90.
different. 90. Second one is
maybe, but you see,
90, 43.
these are all different account numbers.
Different.
These cannot be the account numbers of a because what they may do.
Yes.
You see, I don't understand why they have done it. For this, the account numbers which you have enclosed to your IA,
Yes.
are these anywhere connected with those?
Account
No,
details. These are account details.
No, numbers are there.
You have given the account numbers here, na?
Yes, account number we have given.
These are account numbers which have nothing to do with the
Nothing,
bank,
none of the three.
with that company.
Hmm.
Does it have anything to do with the bank
These-
account?
My lord, if you see the account number, it is a 16-digit account number. Kindly see, my lord.
Where?
What is that? Where is that?
It's not fixed. 4, 3, 4, 5, 6, 7, 8, 9 digits.
Yes, that's, my lord. We'll kindly see. That's what at page 45. 45. It's 1, 2, 3.
Who is investigating this, madam? Huh? No, somebody has submitted all these documents, huh?
ESP Kamrup Amingao submitted the affidavit.
What is that PS case number?
Wrongya PS case number 944 of 2020.
You do one thing. On 28, ask him to be present and give him a very clear instruction. Let him bring the CD. Very clear instruction as regards the account numbers which have been mentioned, where the amounts have been transferred, whether they were found to be of Quicksilver Solution Company. You have got a copy of the IA today? No, wait. You have got a copy of the IA today? Now kindly see, there, page 23, there is a Ministry of Corporate Affairs. There is in respect of a company, Quicksilver Solutions Private Limited. How is this company related here?
Which one, my?
This Quicksilver?
Because this is the beneficiary transaction is Quicksilver. Transaction is Quicksilver. Beneficiary transaction is Quicksilver, my lord.
You see, if I'm not wrong, you can very well put the name. If I'm not wrong, the beneficiary's name when you make the payment. This is just for example, your name. You can very well put your nickname or whatever name in that internet bank where it will go. You don't need to put that name. On the account, nothing will come up as regards that name. But whatever name you put will come in. So therefore, you cannot say that it is Quicksilver this company, because this company may not have nothing to do with this, because it has its entity out there in Delhi or so on. You have out here at page 45 is your statement of account. In this statement of account, you have mentioned which are the account numbers in which it has gone. You just get your instructions on this. Which are the account numbers in which it has been set? No. As regards this Quicksilver, you see, all these have a different account, same account. They cannot be a same UPI for both. There cannot be a same reference number for both transactions. Whenever it is same, that means there is a similarity as regards the account number.
There is another, your lordship, page 47, for a moment.
Yeah.
Here some account numbers have been given by this is a, I think, copy
Personal
from,
complaint.
here some account numbers have been, when it's the same account number all.
Is this petitioner account?
And these are all being made by this Tulika Deka,
Tulika data.
the person who make all these things.
These are petitioner's account. I think petitioner.
This is a petitioner's account.
Daughter's account. Daughter's account.
No, his account.
No, that fraudulent lady.
Person's account for
Who did.
Forest Sunder Tech.
Now, these were all made on 33, 10, 310,
Yes,
310, 310, 310, all these.
Merchant Port is shown as pay
Corporate reference
corporate
number,
reference number is also
pay you code.
and the affidavit of SBI also.
Mr. Counsel for the SBI, you kindly ask some person of the SBI to be present on 28th, who can be more easier to explain to me about this thing. It is not for any particular person, any person who knows about it. Because they know the technicalities as regards the banking. How these things, like earlier I asked, there was one person who came over. Not picking any, but you ask somebody to be present on your own. I'm not asking any order to them. Ask him to be present. Who can explain these documents in a better way. And madam, if you can ask your investigating officer as to whether they have found out whose account, because if you see page 54 of your affidavit, you categorically say that these account numbers belong to these accused. You see, those money were transferred to two numbers of accounts, so and so, which belong to, which accounts were belong to Soed Ahmed Loskor and Rashid Ahmed respectively. And these accounts which have been mentioned where the entire amount have been transferred, Because later on you say that these amounts have been that after getting the bank statement from the complainant from which the money was funded in transaction, IO analyzed and found that those money was transferred to two numbers of accounts. So and so. Whose accounts were these? So they mentioned that these are of these two persons. Whether there was an intermediary transfer from the petitioner's account to somebody and then to this, or was it from the petitioner's account to this? Okay, you kindly explain to it. Okay, list the matter again on 28/5/2024 for further hearing at the top of the list. Ms. Yuda, the learned additional senior government advocate, is asked to inform the investigating officer of Rongia PS case number
944 of 2020.
to appear before this court at 10:15 along with the case diary in respect to the said police case, said case. Mr. Keda, appearing on behalf of the State Bank of India, shall also obtain further instruction as to how the account details which have been mentioned is to be appreciated, how the State Bank would like to explain on the account details of the petitioner's account, and would further like to take instructions in respect to the account details of the petitioner. The application for the interlocutory application which have been filed by the respondent number 9,
10 and 11.
10 and
10 and 11.
then shall be further considered on 20.
I'm deeply aware. Deeply aware.
You file your protocol. If you don't,
Yes, we'll find. I don't know.
Because I have filed the case that they have got the injunction against the debt certificate given by the debt recovery tribunal. That certificate recovery officer has issued the certificate. They want the injunction against that certificate when the appeal is pending in the appellate tribunal court in Calcutta. Your lordship will come to the next step. 5 is 46. This is the judgment of the tribunal whereby the respondent number 1, 2 has been held default in paying the personal guarantee, and respondent number 4, who was earlier there, was exonerated from the recovery matter. Because what happened here, two land matters, Schedule A and Schedule B. Schedule A land was given by the landowner, and the Schedule B was given by the present respondent number 1 and 2 as a collateral security. That is a personal guarantee they have given. After the adjudication of the case, the court has come to the finding that the Schedule A land is being disputed, my lord, because of the false mortgage. So the money to be recovered from the Schedule B land. Against that, the recovery certificate was issued, and accordingly, the recovery certificate was on the process, and the plaintiff petitioner has filed already a suit before the appellate tribunal in Calcutta regarding the judgment. In the meantime, they have come before the civil court and filed the injunction title suit and asking for a permanent injunction against the recovery certificate. That is the issue, whether it is as per admissible under the Act, when the Section 18 of the Act says that no other jurisdiction can enter it.
Did the directors out there give personal guarantee?
Who, the respondent number 1 and
They gave personal guarantee in there?
yes, personal guarantee by collateral mortgage of their land.
They gave it.
Yes, that is reflected in judgment itself, my lord. I would like to draw your lordship, page 46. Page 46. That is the judgment, my lord, of the DRT. The lordship will come to the last page of the judgment. The long judgment. Yes, last page, my lord, that is 71.
Did they raise this issue before in the,
Before I raised the issue.
no, there?
Where?
They must have appeared in the,
Yes, they have appeared, but they was dismissed because they have not deposited the statutory amount.
this is done under section 17.
No, my lord, they went under the section of the RBI Act because they went against the order of the recovery officer.
No. OA,
OA,
did they appear out there?
yes,
No.
yes, must have contested.
And in that, did they raise this question of?
Yes. I'll not well to it. They have raised the issue. That your lordship will find page 50. Since no payment, 5049. May I read my 49 last paragraph.
They filed jointly written statement?
Who they filed? We have filed.
No, there, in the OA.
Yes, they have filed.
In the OA, did they file a joint written statement?
Yes, they have filed.
I'm asking you whether.
Respondent number 1 and 2, man. Yes, they have filed, man. They have contested. They are the director of the respondent.
No, by filing the, no, 1, 2, and 3 have taken the plea that there is no cause of action. Who were 1, 2, and 3?
1, 2, and 3, my lord.
Okay.
Of the OA, my lord.
4 took a different plea.
1, 2, 3 of the OA, my lord.
Now, let's see the DRT Act.
Section 70. My lord. The bar of Before is also applicable to lot of the Enforcement Act. My lord. To take the 30.
Yes, Mr. Sharma.
My lord, in the plaint, I'm referring the plaint, my lord, and a specific para 8 of my plaint, it's page 18. I will refer to para, start from page 18, para 8. But exactly the matter was. That it may not be out of place to mention here that at the time of taking of the loan from the
Page,
defendant,
para.
para 8, page 18. Defendant number 1, various printed documents were required to be signed by the plaintiff as a director of the defendant number 2. There were documents for creation of the mortgage of Schedule A land, which were signed by the plaintiff as a director of defendant number 2 and pro forma defendant number 3 as the landowner of the land. Besides that, a collateral security was also executed, also created in respect of the plot of land measuring 1 bigha as described in Schedule B herein below. The said plot of land belonged to plaintiff, who were the director of to the defendant number 2 in favor of the defendant number 1 for the purpose of securing the loan. That it may pertinent to mention here that the defendant number 1 for the purpose of securing its money got the primary security of Schedule A land as well as the collateral security of Schedule B land. Apart from above, the defendant number 1 insisted the plaintiff to sign a typed and printed paper containing the personal guarantee by the plaintiff. Finding no option, the plaintiff on good faith.
Yes, why was there no option?
Because, my lord, I require.
You took the loan.
I have to complete the project within a limited period of time, and I had no money, sufficient fund.
Don't take the money from them.
So
If
for
they
that-
had these conditions, you were to sign it.
So for
Did
that-
you challenge at any point of time thereafter? Did you challenge these loan at any point of time thereafter? In fact, you, along with defendant number 2 and 3,
My lord.
along with the defendant, the plaintiffs and the defendant number 2 together filed a written statement.
Yes.
You did not allege anything against the defendant number 2 there.
In the written statement, we have taken the plea that the director cannot be personally held to be liable of the company, and know that personal.
No, not personal liability, but you have given a personal guarantee.
Yes,
Then-
that paper I have challenged there, but there no issue was framed, no chance was given to adduce the evidence because it is a
If
DRT.
it was no chance being given, you have an appeal out there, you have raised that appeal out there, the appeal is pending out there.
No, appeal was disposed of.
So now therefore you have filed a suit.
The suit is not only against the HUDCO, my lord, against the partners also, my lord. Let the prayer portion may kindly be looked into. In page 23.
Yes.
Declaration that the findings so arrived at by the learned debt tribunal in OA 63, hastening the plaintiff with the liability of repayment of dues and debt of the defendant number 1 on the basis of the loan agreement dated so-and-so, and the personal guarantee dated 25/1 is illegal, unlawful, unfair, unethical, opposed to public policy and cannot be enforced in law. Second, for declaration of the contract of the loan dated so-and-so containing clause of the execution of the contract of personal guarantee by the director of the defendant number 2 for securing the loan in favor of the defendant number 1 is illegal, unethical, void ab initio. Third is for declaration that the document of personal, this is also same. Then fourth one is for declaration that the plaintiff cannot be held personally liable to the liabilities of defendant number 2 with the defendant number 1 in respect of the loan so sanctioned by the defendant number 1 in favor of defendant number 2. For declaration that the plaintiff have right to claim the values of the plots of land as mentioned in Schedule B from the defendant number 2. What happened, my lord? Schedule B was my plot of land. It was put in collateral security. Then I resigned from the company. So I demanded the value of my property, which was they have taken away. So they refused to give it the value.
Who?
Because property already sold it.
Who refused to give?
Defendant number 2.
So if the defendant number 2 has refused, so
Yes.
how do you make the defendant number 1 a party in the suit?
Because, my lord, the entire.
They have nothing to do with this against the defendant number 2.
my
Your
lord,
suit
because-
otherwise is not maintainable. And that too, when you file the written statement together with the defendant number 2 in the earlier proceeding,
No,
you have
my-
raised the same issue there. and having not been successful, then the appeal has been filed. Appeal being not successful, you file a suit.
Now, by that time, my lord, I retired from the.
Lord, the last
civil service.
You have retired or not
last
retired, your guarantee will be continued.
I
My lord, the last prayer, my lord, of 24 for permanent injunction against the defendant number 1, that is me,
and
for restraining from execution the realization of money
prayer
by the
6.
recovery officer.
Let me complete. Prayer
No, no.
6, my lord, for recovery of.
Yes, Mr. Sharma, you only show me one judgment which will help you. Otherwise, there is nothing.
My lord,
Only thing this court is going to pass is a judgment against you now.
first of all, my lord, I am reading prayer 6, my lord.
No, prayer doesn't
For
arise.
recovery of 3 crores.
I've read it. I'm only asking you, do you have any judgments to show that section 17 is not, 18 is not applicable? Show me that.
Yes. Now,
In these
first
facts.
of all, my lord, the one thing is that this suit so far the defendant number 2 and 3 is concerned is maintainable. Let it be, my lord. If the lordship says that personal guarantee, personal guarantee bind with me because I signed it. Even then, my lord, I am entitled to recover the rupees 3 crores from the defendant number 2 and 3 because it is my property and it was put in as a collateral security. When they refuse to give it, so I have to file the suit for that against that. And regarding the personal guarantee also, my lord, section section 20, 23 and 10 against that because it is against the public policy because director cannot be held to be the personal liability. And this document was to be signed.
Personally, you have given a personal guarantee.
Personal guarantee, my lord, it was to be signed on that situation, my lord, I have stated it.
You have signed it.
Yes, we have signed it. And that court is to look into it under which circumstances, whether there was a free consent or not.
Whether you have raised those issues before the DRT have already decided that.
The DRT has not even put that framed the
Against
issues, my
that,
lord.
an appeal against that appeal, there was a
lord,
Supreme Court, you should have gone there.
DRT, my lord.
You
so far the-
cannot make abuse
so
the
far
process.
the jurisdiction of the DRT is concerned, my lord. Section 17, DRT can only for realization of the dues
Mr.
to the
Sharma,
bank.
do you have any judgments?
Yes, I will
Yes,
show,
show
my
me
lord.
that.
Before
Any
that, my lord,
judgment which may help you out.
before that, my lord, section 17.
No, not 17. You
jurisdiction of
kindly
the
show. I've read
jurisdiction-
section 17, Mr. Sharma. Kindly show any
Yes,
judgment you
yes.
may have.
Now, my lord, they will find here, my lord, my submission will be that one part of the suit is maintainable because it is against defendant number 2 and 3. When
Don't worry, I'll take care of that. You just show
and
me with.
upon that, my lord, the judgment is 2018 11 SCC and 2019 7 SCC.
What are the
Two judgments. And regarding, my lord, the jurisdiction of the DRT court, my lord, DRT court is not a civil court, and that issue cannot be decided by the DRT court, my lord. Because when I have taken the plea, no issue, nothing was framed, no chance was given for editing the evidence, and DRT court has no power to look into that.
Okay, now I
One,
dictate.
one more, my lord, regarding the powers of the DIT court, because DIT court is not the civil court, and these matters are to be decided by the civil court only, my lord. Beyond the jurisdiction of the DIT court, my lord.
This is an application under 115.
One more,
227.
227, how is it maintainable?
My lord, as per the act, my lord, the 17 act is, my lord, 227. The act is, it should be ready to 115, my lord.
You have
but
given it 115.
it was not there. But it is in the act says 227. Yes. In the section 17, my lord. See,
No. I can't convert a 227 into 150. Sorry. Because 115 question is different. When did you file it?
I felt it as 2021.
15/12/2001 within limited. This is an application under Article 227 of the Constitution challenging the order dated 11/11/2021 passed in Mizze case number 78 of 2020 arising out of title suit number 306 of 2018, whereby the learned trial court, that is the court of the civil judge senior division number 3, Kamrup Metro at Guwahati, had rejected the application filed for rejection of the claim in terms with Order 7 Rule 11D, read with Section 18 of the Recovery of Debt Due to Banks and Financial Institutions Act 1993. For the purpose of deciding an application under Order 7 Rule 11D, the requirement of the law is to see as to whether from the statements made in the plaint, the suit is barred by any law. Therefore, this court constricts itself to the averments made in the plaint as well as the documents enclosed therewith. From a copy of the plaint, it reveals that the plaintiffs number 1 and 2 were admittedly directors of the defendant number 2. In the course of business, the defendant number 2 had taken a loan of rupees 1.8 crores from the defendant number 1, the oblique bracket, the petitioner herein, which was sanctioned by sanction letter number HUDCO oblique ZO-NE oblique landmark oblique 18725 oblique 2005 oblique 1987 dated 9/9/2005. By keeping the Schedule A land to be the primary security and Schedule B land and others as collateral securities, as per the agreement executed between the defendant number 1 and 2, as well as the pro forma defendant number 3. It was alleged in the plaint that at the time of taking of the loan for the defendant number 1, various printed documents were required to be signed by the plaintiffs as directors of the defendant number 2. There were also documents for creation of mortgage of the Schedule A land, which were signed by the plaintiff as directors of the defendant number 2, and the pro forma defendant number 3 as landowner of the land. Besides, there was also collateral security was created in respect to the plot measuring 1 biga as described in Schedule B to the plaintiff. Which the Schedule B land belonged to the plaintiff, who were the directors in the defendant number 2. It was also stated that the defendant number 1 insisted that the plaintiff to sign a typed and printed paper containing the personal guarantee by the plaintiffs. The plaintiffs, on good faith, signed the printed letter of the defendant number 1, which contained personal guarantee of the plaintiffs in respect of the loan so sanctioned in favor of the defendant number 2 on 25/4/2007. It was further stated that the plaintiff number 2 retired on 11/4/2007, and thereafter the plaintiff number 1 retired on 28/6/2016. And accordingly, their names were deleted from the record of the Register of Companies and at the time of filing of the suit, the defendant number 2 had been doing business with the director, Devi Shankar Kaur and Mary Das. It was further mentioned that the defendant number 2, till the date of retirement of the plaintiff, owed the plaintiffs an amount of rupees 3 crores and the plaintiff was to receive the said amount from the defendant number 2. Be it as it may, although the plaintiffs have retired from the directorship, the property described in Schedule B was not freed from the collateral security with the defendant number 1. And as such, the said property was kept in charge with the defendant number 1 as a collateral security for sanctioning the term loan in favor of the defendant number 2. It was further mentioned that the plaintiff, on their retirement from the defendant number 2, demanded rupees 3 crores, being the value of the plots of land as mentioned in Schedule B. But the defendant number 2 avoided the request on the plea one after another, and ultimately on delivery of the judgment dated 28/6/2017, passed in OA number 63/2012 by the learned DRT Guwahati, the defendant number 2 on 11/4/2018 refused to pay the same, which compelled the plaintiff to bring the suit. It was further mentioned in the plaint that the defendant number 1 had initiated the proceedings before the Learned Debt Recovery Tribunal Guwahati, which was registered and numbered as OA number 63/2012 for realization of the money from the defendant number 2 in respect of the loan so sanctioned by the defendant number 1, along with accrued interest thereon, due to non-performance of the escrow account by defendant number 2. In the said proceedings, the plaintiff, defendant number 2 and the performer defendant number 3 were arrayed as defendants. The said proceedings were duly contested by them, and finally on 28/6/2017, the learned DRT allowed and decreed the claim of the defendant number 1 by holding that the plaintiffs and others to be liable for the payment of the debt of the defendant number 1. The said judgment passed by the learned DRT have been enclosed as plaintiff document number 1, and as such, taking into account that has been enclosed as plaintiff document number 1, this court, in exercise of the powers while adjudicating an application under Order 7 Rule 11, would be within its powers to look into the same. In the said proceedings before the DRT, the Debt Recovery Tribunal Guwahati, the plaintiffs herein, along with the defendant number 2, the plaintiffs of the suit, of the present suit, along with the defendant number 2, jointly filed a written statement. And the performer defendant number 3 filed a separate written statement. In the said written statement, the plaintiff number 2, it was contended that the plaintiff number 2 is no longer one of the directors of the defendant number 1. Plaintiff number 2 was no longer the director of the defendant number 2 here of the suit. And the plaintiff number 2 had resigned from the said directorship with effect from 11/4/2007. And thereafter, the plaintiffs had dissolved their marriage by mutual consent. It was further mentioned that the board of directors of the defendant number 1, of the defendant number 2 of this present suit, by resolution dated 2/5/2012, had authorized the plaintiff number 1 to take necessary steps for and on behalf of the defendant number 2 of the present suit. It was further stated in the plaintiffs as well as the defendant number 2 again took another joint plea that the personal guarantee agreement dated 26/4/2007 executed by the defendant plaintiffs in favor of the defendant number 1 of the suit as security against the loan sanction is void agreement and without authority of law, as it is a settled law that the rights and liabilities of the surety and the principal borrower are different and distinct. It is further relevant to mention that the plaintiff number 1 herein adduced evidence on behalf of the defendant number 2 of this instant suit in the said proceedings before the DRT. The learned DRT, after taking into consideration the various materials on record, passed the judgment dated 28/6/2017, thereby directing issuance of a recovery certificate in favor of the respondent number, the defendant number 1, bracket the petitioner herein, for an amount of rupees 2,67,19,810 against the defendant numbers 1, 2, and 3 jointly and severally therein, bracket the plaintiff number 1 and 2 along with the defendant number 2, with pendant right and future interest at the rate of 13.50% per annum with quarterly less rest till realization of the amount in full along with cost of the application. The performer respondent of defendant number 3 was not fastened with any liability of the defendant number 1 of the defendant number 2 of the present suit. Pursuant thereto, on 30/6/2017, a recovery certificate was issued. And thereupon, a recovery proceedings was also initiated. At the time when the recovery proceedings have been initiated, the present suit is now being filed, was filed in the year 2018, seeking the various reliefs to the effect that the plaintiff number 1 and 2 cannot be fastened with the liability on the basis of their personal guarantee dated 26/4/2007. In addition to that, it was also prayed that the defendant number 2 is liable to pay to the plaintiffs an amount of rupees 3 crores being the value of the plots of land as described in Schedule B to the plaintiff. In addition to that, a permanent injunction has been, however, sought for against the defendant number 1, the petitioner herein for restraining it from execution of realization of money by the recovery certificate dated 28/6/2017 in OA number 63/2012 against the plaintiffs. Upon the suit being filed in the year 2018, there is an injunction order also being passed. An injunction application was also filed. And the learned trial court, by then ordered it. Where's that order?
83 page.
Huh?
83 page. 11/11/21.
11/11/2021. Now, this is the impugned order.
Yes.
No, is there any injunction granted?
No,
No injunction. So have you not been able to go ahead?
No, my lord, on the filing of the written statement and other materials, my lord, I immediately filed under order 7, rule 11 for rejection of the claim on.
Now, did he get an injunction?
No,
There's no injunction.
no.
The injunction. Then what remains in this case? Let it go ahead. It will be good for you. At the end of the day, he will lose.
Well, but the
Already they have recovered a huge amount of money, even
It's
by
okay.
selling my property, everything.
But the order which they are asking for in the injunction is the permanent injunction against
So what?
for recovery of against the recovery. of the-
You can very well say that it cannot be granted.
That is why we have filed order 7 to 11 to reject.
Can't recover. How can you be when he is asking for something
No, he is asking against us.
against the defendant number 2 also?
No, your lordship will see the
He is also asking for defendant number
number
2.
2. I have no objection to defendant number 2.
How do you bifurcate?
So that observation, your lordship. That we are that any injunction matters that is not applicable.
Why should I say now? Or you want to render me to go to
No,
that?
but not that. But even under my lord, the
Wait, wait,
relief
wait.
act.
I've heard Mr. K. Bhattacharjee, the learned counsel, appearing on behalf of the petitioner. Against that, an application was filed under Order 7, Rule 11D. Now, pursuant to the filing of the suit, the defendant number 1, who is the petitioner herein, filed an application under Order 7, Rule 11D for rejection of the plaint in view of the fact the said application in view of the fact that the suit was barred in terms with Section 18 of the Recovery of Debt and Bankruptcy Act 1993. On the ground that from a reading of the statements made in the plaint, the suit was barred under Section 18 of the Recovery of Debt and Bankruptcy Act 1993. The said application was rejected by the impugned order dated 11/11/2021, and as such, the present application. This court upon this, I've heard Mr. K. Bhattacharjee, the learned counsel, appearing on behalf of the petitioner, and Mr. J. Sharma, the learned counsel, appearing on behalf of the respondents. From a perusal of the and have given due consideration to their respective submissions. From a perusal of the plaint, prima facie, it appears that the issue which have been raised by the plaintiffs in the present suit was also raised before the Debt Recovery Tribunal, which was rejected. And consequently, the order was passed on 28, judgment was passed on 28/6/2017. In OA number 63/2012 by issuing the recovery certificate. However, However, that is one part of the story, as is one part of the plaint which could be seen from a perusal of the plaint. But the other part of the plaint further states that the plaintiffs have also claims against the defendant number 2 in view of the recovery proceedings which have now been initiated by the bank pursuant to the proceedings, pursuant to the judgment dated 28/6/2017 in OA number 63/2012. And the subsequent issuance of the recovery certificate. This issue as to whether the plaintiffs would be entitled to any claim against the defendant number 2 is not an issue either decided by the DRT in its judgment dated 28/6/2017, nor the bar contained under Section 18 of the Recovery of Debt and Bankruptcy Act 1993. Affects the right or bars the plaintiff to make such claim against the defendant number 2. At this stage, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Madhav Prasad Agarwal and another versus Axis Bank Limited and others reported in 2019 7 SCC 158, wherein the Supreme Court categorically observed that the plaint as presented must proceed as a whole or can be rejected as a whole but not in part, or for that matter. The provisions of Order 7 Rule 11 can only be exercised to reject the plaint as a whole or to either accept to reject the plaint as a whole, and there cannot be part rejection of the plaint. Taking into account that the plaintiff may have a case against the defendant number 2. And the entire suit have been structured in, it may have a case against the defendant number 2, which in the eventuality the plaintiff may win or lose, cannot be a ground. Taking into account that the plaintiff has disclosed a cause of action against the defendant number 2 in respect to a claim pertaining to the Schedule B property. This court is of the opinion that the learned trial court was justified in rejecting the application under Order 7 Rule 11D, so filed, by the impugn order dated so and so. Under such circumstances, this court finds no merit in the instant proceedings for which the instant proceedings stands dismissed. Full stop. Taking into account that the parties are duly represented, the interim order passed on 7/2/2022 stands vacated and the parties are directed to appear before the learned trial court on 15th of July 2024 for further proceedings.
I think the third problem. There's additional request to Mahakam. That the wife that yes, 505 days. Yes,
2 weeks time may be given for.
Huh?
2 weeks time may be given
For what?
to file an affidavit in opposition.
For what?
Your Honor, he is telling that she resides in Haflong, but we are saying that she resides in Kachar district. Paragraph 2 of the petition. Where actually marriage was solemnized.
Then where?
Paragraph 10 of the petition, where she has actually written the reason of that transfer. CR BV case number 4/2022 is pending before Haflong. She is telling that, but this case has been disposed of already. And for her advantageous condition, this particular case was proceeded ex parte, and ex parte order has been passed. This particular case, because my condition is that
You want your wife back?
yes, absolutely.
Go to Karimganj, Haflong and get it.
Yes, we have done there several times.
Go to Haflong and fight it out in Haflong and get it.
For me, going to Haflong was very, very tough.
For her, it is okay.
They are saying that 140 kilometers away, how Karimganj court is.
And for you?
For me also, 140 kilometers away is Haflong court, but he
Well,
resides in Kachar district, only 40 kilometers away from Karimganj court.
Kachar.
Yes.
My lord,
Who stays in Kachar?
Why? There's
Why
a petition.
she stays in Haflong.
She is claiming that she lives in
page
Haflong.
19 of the summons issued by that.
You issued a notice where? Show me here. What have you placed her address there?
Water Tank Road, Convent Road.
Haflong, why?
Yes, we have issued notice in both the address. In Kachar district also and in Haflong district also.
You stay in where?
Haflong.
Go to Haflong. Transfer. Appear on 15/7. File your written statement there.
Lord.
Dispose.
Right.
This is for what? Enhancement?
No, Lordship, they have come for modification of the award of there was a direction to fix the awarded amount, Lordship. Some amounts may be released and some would be fixed, Lordship.
The applicants are entitled to exemption. The applicants are directed with the above direction.
RCT has
So this is a case for enhancement?
no, Lordship.
For what?
For modification, Lordship.
Why?
Lordship, a part of
They want more money.
No, Lordship. No, Lordship.
They want less money.
8 lakhs has been awarded, Lordship. A portion should be released to the appellants and other portion should be invested in a fixed deposit.
So
And
they want the change of this.
all this amount they require release of all this amount.
Okay. You have paid some money.
I have no interest. Maybe Lordship.
Hello, we admit this.
But-
Admit so and so appears on behalf of the railways. No extra copy is required. You have a copy?
Yes.
Okay. No extra copies are required. Call for the LCR. This is the matter after completion of the after receipt of that. For here.
Similar matter, madam. Similar matter.
Same order. Ali, naam to both right. You have a copy?
Yes, I believe.
appeal admit, call for a record. List the matter. So and so appears on behalf of the respondent. List the matter for hearing immediately after receipt of that. With a take care. Huh? Yes, what is this? For?
Statutory appeal method.
For what?
Claim has been dismissed by the railway tribunal.
Dismissed. Appeal admit, call for a record, so and so appears on behalf of the respondent. Extra copy of the memo of appeal which serves upon him. List the matter immediately upon receipt. Yes, Oriental Insurance.
Respondent number.
None appears on behalf of the appellant on call for end of justice matter sent adjourned to be listed of 2 weeks. Hmm.
Okay, state to appeal also under railways.
MFA again?
Okay.
Enhancement?
No, Lord, it's a punitive charges. Punitive charges.
Okay. Call for appeal. There is a stay application. How much is the amount?
Okay, amount is Lord, 3,51,970.
Okay. They're going to appeal to admit for call for a record. Issue notice making it returnable. Steps within 3 days by registered as usual. And to go to not call issue notice. Step by way of registered as usual. Step to notice making it returnable to 6 days. What is this?
My lord, by this case, my lord, but brought the lordship is that, my lord, an attempt, my lord, by the executing court to change and rewrite the decree, my lord.
Huh?
An attempt by the executing court to rewrite the decree, my lord. If your lordship turns to page 101.
Yes.
Here your lordship will find it's a petition made under order 617 to the executing court. A title execution case by which it is stated that while filing the above noted execution case, the schedule of the land was described as its present stands changed condition, and as such, it did not tally with the description of the schedule of the decree in toto. Now it appears that the process of execution becomes difficult to execute the decree without the original description of the schedule of the decree. Under the circumstances of the present schedule of the
Where is the order?
Order is lordship at page 120.
Huh?
122, 123. And even the amended decree, my lord, the draft decree also has been submitted by the party.
So what is wrong with this order?
Hello, sir. Schedule then has been changed.
Did you learn as per the decree?
Oh my God, as per the earlier decree and the my lord counter decree. So lordship kindly turn to page number 89. That is in vernacular. The last portion may I read out. পুরোনো 34 নং মেয়াদি পট্টার 135 নং ডাগর বর্তমান 43 নং মেয়াদি পট্টার 182 নং ডাগর 1 বিঘা 1 কঠা 10 কাঠার মধ্যে দক্ষিণ অংশ 2 কঠা 10
Oh,
কাঠা
you see, the executing court is taking in action in terms with section 47. What is wrong with this order? This is in terms with section 47. The executing court can very well look into this in view of Pratibha Singh's case.
That is official. That person now he claims that somebody else is there over that property.
He is not executing what he is asking. He is asking the superintendent and asked to depute one person and so. Order at the site of the and consider it is hereby ordered regress and take steps for issuing of the possession warrant. Hereby directed to look into and take necessary steps. But Mr. Dhar, without identifying the court, how did the court pass the later portion of the order? If you see the paragraph page 125, the first two paragraphs, it says that there was a direction to identify to the circle officer as well as the left control they have not done. And as such, there is a direction to the deputy commissioner to do the needful. Now, at the same breath, how can the court direct for possession
My lord,
unless that is being complied?
I can understand, my lord, but in my humble submission, there are many facts that have been suppressed from this before this honorable court. My lord, in fact, there was amendment done in the execution proceeding. I'm just handing over, and there is an order passed in a miscase whereby the amendment was allowed. My lord, these were not before your lordship.
Suppression.
Suppression, my lord. I don't know. They have not stated. I will not say
As per you, is
suppression.
it suppression. Today, whole day, I have not given any cost. My daily limit is 1 lakh. But today, I have not given any.
Minus the amended petition, your lordship will file that it is on 2nd of November 2022. And the schedule, your lordship, this is the schedule. There is no change in the schedule.
Where, which page?
In the amendment title execution.
Yes, this one.
This one. Last page, suit length. The part is already expired. The original plaintiffs, original defendants, they have already expired.
A plot of land measuring 2 kata 10 acres out of the southern part of the total land of so covered by periodic patta number so, which is bounded by so.
There is no change, my lord. And your
So
lordship,
this is as per the decree.
as per the decree, and my lord, my senior friend has not annexed the decree also. Decree is also there.
Show me that. This one.
No, my lord, I have just.
What is this?
This one is an order
By which it was allowed.
by which it was allowed. The lordship will find Ulta Dabi Topsil, that page 4. I mean, page 3rd page. Ulota Dabi Topsil.
It's as per the decree.
As per the decree, my lord. And this has been suppressed.
No, understood. That is okay. But how the trial court gave the executing court on one hand directed the deputy commissioner to identify.
Yes.
And at the same breath, issued recovery of possession on the same date, at least
My
page
lord, there
125.
was another order which I have not filed the affidavit in opposition. but there is previous orders of this court, the executing court. On 25th of May 2023 and 23rd of June 2023. On those days, these decree judgment debtors were absent. And certainly they are aggrieved by this order. They are
Okay. Hello. So this is a case of cost. There is no more matters. So 1 lakh is you.
Without identifying, my lord.
What is there identified? It has already been identified that there is a specific direction given. And you have not enclosed these aspects.
I did not have it.
So 1 lakh on you. So let us reduce my total burden 25,000 to minimum so that I can think about the rest of the matters. How many matters are left? So there I can distribute the 75.
Today is the Wednesday.
Huh?
today
Today
is
is the Wednesday.
One is there, 1 lakh. There are many more matters. This is an application under Article 227 of the Constitution challenging the order dated 11/8/2023 passed in title execution case number 3/2015, whereby the learned executing court, that is the court of the district judge Dhemaji, had directed the learned district judge Dhemaji, taking into account the non-compliance to the various earlier orders passed to the circle officer as well as the lot mandal, had directed the Deputy Commissioner Dhemaji to look into the matter and take necessary actions. In addition to that, the Superintendent of Police Dhemaji was also asked to depute one section of armed force, bracket, including male and female, on payment of the required cost by the decree holder at the site of the SUPLAN. The Circle Officer Dhemaji Revenue Circle was also directed to depute Lot Mandal to be present and assist the civil Nazis for proper execution of the decree on the date fixed. Mr. G. Chaudhary, the learned counsel appearing on behalf of the petitioner, submitted that the learned executing court had changed the, while passing the order, had changed the schedule of the land. And as such, the said order is not at all chainable. On the other hand, Mr. Adhar, the learned counsel appearing on behalf of the petitioner, on behalf of the decree holder, who is the respondent in the instant case, submitted, who are the respondents in the instant case, submitted that the decree which is being sought to be executed is in respect to the same schedule which have been decreed by the learned trial court. In that regard, he, during the course of the hearing, has placed before this court the original decree which has been passed by the learned trial court, which have been affirmed by this court also. And further, the amended title execution application wherein the schedule of the decreed land have been duly mentioned.
Had the plan now been similar to the decree, these petitions which I have shown at page 101 is made by the decree holder himself. He says that the decree is not in control. That schedule is not in conformance.
Understood. Therefore, that amendment has been done. In fact, that was the application seeking amendment. What you read.
My lord.
That is why it is Order 6 Rule 17.
Yes.
They did not seek any amendment. They seek the amendment of the execution application. Taking into account the above, this court finds no infirmity in the order passed by the learned executing court dated 11/8/2023 entitled Execution Case Number 3/2015. Accordingly, the instant petition therefore stands dismissed. Further to that, the interim order passed on 22/9/2023 stands vacated, and the parties who are duly represented are directed to appear before the learned trial court, before the learned executing court on 10th of June 2024. This court further directs, further taking note of the order which have been passed by the learned executing court and the non-compliance to the specific directions being issued by the learned executing court to the lot mondal as well as the circle officer, by the lot mondal as well as the concerned circle officer of the Dhemaji Revenue Circle, directs the Deputy Commissioner Dhemaji to take appropriate steps so that the decree which have been passed by this court, by the learned trial court, can be executed in accordance with the true spirit. The Superintendent of Police, Dhemaji, is also directed to do the need.
Apply.
Appeal against the order of divorce, my lord.
Huh?
Against divorce, my lord. Decree of divorce passed by the learned additional district Nagaon.
Divorce granted.
My lord, actually, my lord, what happened? Advocate, legal aid counsel was appointed for the wife. He did not appear. So, my lord, after cross-examination, my lord, neither DW, my lord, file, my lord, no argument was put on her.
Appeal admitted, call for the record to notice steps by registered as well as you within
Public.
number 6. And appeal admitted for yes, Mr. Raj.
Taking appeal against the order passed by the Commission for Employment Capital. So, for example, in this case, the doctor said that the disability is not permanent, it's temporary. And doctor made no loss of estimate of loss of earning. And
How much is the
does not
amount
have the
given?
power to do it, commissioner did it by him. Without that, commissioner
This is
does not
under
have to
what
do it.
provision?
Doctor,
EC.
EC.
Show me what is a substantial question of law.
In the first synopsis, I said.
Whether the given facts where, as per the doctor, the workman has not suffered permanent disability, the doctor has not made any assessment of the loss of earning capacity. That's one.
Yes.
Here the doctor was present.
Doctor was present. He was examined. His evidence has been recorded in the
And as per him, there is no permanent disability.
he said disability is temporary. It will have to be reassessed after 3 years. First, I'll just read out a particular part of the judgment.
Yeah.
Page 12, Lord. Issue number 3.
Issue number
3.
Okay.
The medical officer, Dr. Parasiti, Dr. Senior MNHO, some member district territorial board, who examined as PWD, who adduced his evidence through video calling after receiving someone by the Joint Director, Self Service Institute, some chairman, who authorized him to adduce evidence.
He stated in his evidence that he examined Sabilal Thapa on 3/5/23 in medical board. He found the following findings. Post-pragmatic deformity of right leg and percent of disability is 40%. It is temporary disability which can be reassessed after 3 years. Presently, he is not able to drive vehicle. That is on. There's no loss of earning capacity. And he did it lordship by him. In this case, I have to rely on a particular judgment of this Honorable Court Lordship. That is New India versus Sanjit Kumar. Where in such a case, Lordship, the matter was remanded to the tribunal for a fresh assessment of the loss of.
So we demanded.
Number 2 and 4. He has suffered something, but it's not given to the commissioner. Lordship. It may be 40%, 30%, 25%, 20%. Pair number 2 and 4. And it's being followed by other judgments of this Honorable.
We do one thing. They have taken as 60% of the monthly salary. Why?
There's a formula.
Huh?
There's a formula.
So 60% they are
In
taking.
case of death, it's 50%. In case of disability, it's 60%.
In case of death,
it is 50%.
Now, if it is not permanent, if it is temporary in nature, would he be entitled to that
No.
as per permanent disability type?
That's something different by definition. Lordship. It has to be permanent. In fact, the formula says so. Cause permanently. Something maybe.
And they have, and the court have also not considered that, because the court holds out there that he would be able to do other work.
Yes.
So if that is so, how much would be the mitigation? Is it, are such questions there?
The definition says to just read out a particular part of what constitutes permanent partial.
So as per you, how much he should get?
He definitely is entitled to compensation.
How much?
Yes, spend medical yes. It might be anything between 20% because it has to be partially permanent. If to qualify for
How much is he entitled to get? As per you, how much he is entitled to get?
It's a guesswork, Lord.
Huh?
It's a guesswork, Lord. So I do not say.
Do the guesswork? How much?
It's held as 40%. It can be 20%. There may not be any. Then it compensation is entitled to compensation because that period is entitled to temporary total disability. Maybe
How much
temporary
is he,
disability.
how much is he entitled
different
to?
formula for that.
Mr. Arguttami, how much is he entitled to? Rough
He is
work.
entitled to medical expenses at that.
Rough work, how much?
Total
Medical expenditure is 4,35,000.
yes, and
So that he will get it.
7,25,000.
Out of 7 lakh, how much is he entitled to get?
If it is
Chalo.
not even permanent,
We make it 3,50,000 plus 4,35,000. Yes, you have a big calculator with you. Calculate 4,35,000 019 plus 3 lakh.
4 lakh.
How much will be 50% of 7,25,976? How much?
50% of 7,25,000, it will be 3,62,988.
Plus add 4,35,019.
So total would be 7,98,000.
Huh?
7,98,007.
7,98,000.
007.
James Bond. 007. 7,98,000. Okay. We state, you deposit this, let him take that money. Rest we'll see. Because he's entitled to medical expenses, let him take it. And that 50% of this will be this month. So 7,98,007, let him get. Sir, we're sending it for remand.
Disposed also for the fund.
Huh?
My learned friend agrees it can be disposed of also for the fund.
Really?
Is not available.
He would not agree. He wants more.
Yes.
He will be happy with this.
Unless
And this will be given in installment of 5,000 each per month to that person.
The doctor has to pay again. Maybe for that purpose also it may be remanded after the payment of.
See, the question of remand doesn't arise now, as of now. I have to frame a question of law. Then only the next date I can, because tomorrow he will say that how can this be, without giving me an opportunity to argue that this substantial question of law does not. Hello, otherwise we can ask him to file a reply. We don't stay next day. The instant appeal is admitted on the following question of law. It basic. Mr. M. Khan appears on behalf of the respondent.
number 1.
Number 1. And as such, no fresh notice is required to be issued. As regards the respondent number 2, the appellant is directed to take fresh steps, by way of registered as well as usual within 3 days. List the matter. Do we require the records? Call for the LCR. Immediately upon receipt, completion of service and receipt of the records, list the matter for a hearing in its future course. Hearing. This is an application under Order 41, Rule 5 of the Code of Civil Procedure, praying for stay of the operation of the impugned judgment and order dated 1/8/2023, passed by the Learned Commissioner for Employees Compensation, Bongaigaon, in EC case number 24/2022. Taking into account the question of law being framed, which is only in respect to in respect to the quantum pertaining to the compensation on account of the injury, and not in respect to the medical expenditure which have already been decided by the Learned Commissioner. This court stays the impugned judgment and decree, the order dated 1/8/2023, till the disposal of the instant appeal, subject to deposit of an amount of rupees 7,98,004 before the registry of this court by the appellant by how much? By 26th of June 2024. Full stop. Upon such deposit, the respondent number 1, herein who is the claimant, would be entitled to the release of the said amount subject to verifications being carried out by the registry, subject to application being filed by the respondent number 1, and after carrying out due verification. I extend it. Yes, what is this?
Second appeal, madam.
Yes. It has not yet been
Admitted.
sued for what? What is your substantial question of law?
Only, my lord, the gift deed has been prepared in favor of the dependent.
Huh?
Whether those gift deed are fraudulent or
What?
valid, my lord. That is the only matter. Whether the deed number so and so are forged or fraudulent. That is the matter. Otherwise, nothing is coming up from the my lord.
But that is not a substantial question of law, fraud or fraudulent. How can it be a fraud or fraudulent? It's a question of fact, isn't that?
Nothing is coming out, but only it also comes only when
Hello.
the
Let me do one good service to the nation by dismissing your petition.
no, but
Yes.
or maybe 1 day or 2 day may be given that so that I may frame another subject if allowed by your lord.
What?
But we have come subsequently, my not the original different advocates, but we have come later. Only 1 or 2 day I may, my lord, if possible, I may.
Your name is what? What is your name? You came subsequently in 2018. And 6 years have passed by and still you are subsequent.
If it's a with
2012, 2018, heard Mr. B. Sena, the learned counsel for the appellant.
Yes,
And then,
I agree, madam. I agree,
then
madam.
subsequent,
Because they have framed the subject question of law, my lord, but in their brief, my lord. So now, my lord, if your lordship do not, my lord, consider that part, my lord, I have to.
I'm not on that. I'm not going to touch that. You say what is the substantial question of law.
Yes, my lord, I have to get it.
Huh?
I have to, my lord, 1 day or 2 days, maybe.
Chalo, let us
Yes.
finish off this month.
Yes, my lord. Yes.
Matter?
Yes.
Chalo. List the matter again on 29th of May 2024.
And
This
it may be
court,
on 30th, my lord.
why? Do you think this matter is of so much
No, on
importance?
the date 28th, my lord.
Absolutely no. 28th, no. This matter is not fit for Monday, Tuesdays and Thursdays. List the matter on 29th of May 2024. Taking into account that Mr. B. Sinha, the learned counsel appearing on behalf of the appellant, seeks for an accommodation to find as to whether there is any substantial question of law involved in the instant appeal.
Alright.
Mr. A.R. Sikdar, the learned counsel, appears on behalf of this court.
Right.
Develop.
So the expert question of law that earlier time was granted to 5%. I think.
Mr. Mehdi, we fix it on 5th of June. I'm not there. You can pass through with those substantial questions of law. 5th of June or 7th of June. 5th. At the request of the counsel for the appellant, matters on 5th of June.
With the appellant before. This suit is for specific components of the agreement for sale.
Hmm.
This
that was executed KF. He is there in the land since 2003, running a motorcycle. Then the other defendant, he filed a counter claim. Both the suit and counter claim.
You filed a suit for? You are a plaintiff?
I'm the plaintiff.
You filed a suit for specific purpose.
performance of agreement for sale. Then the defendant also filed a counter claim for my fix of suit. So both the suit and as well as counter claim. Then defendant filed an appeal. In appeal,
The suit was decreed, counterclaim dismissed.
both.
Huh?
Both.
How?
Eviction and it says that they will evict us competent, then on the execute the sale. That was the fee.
Then?
Then they have filed an appeal. Appellate court decided the issue number 4 and 5. So far as specific performance conflict is concerned, it has been referred on the ground that regarding readiness and willing.
Yes.
As per appellate court, no readiness. And so far as the bar by limitation is concerned, that is also equal. Now, before Lordship sees the claim, there is specifically stated regarding the readiness and willing.
And
Trial court Lordship, on the basis of some decisions of the Supreme Court, without deciding how the facts of those cases fit into the in our present case, relying on it says that there is no readiness and willing. And for that purpose, Lordship,
wait. First, let us go into the question of limitation. Limitation went against you. Limitation point went against you.
yes, by the appellate court.
Yes.
Reverse it.
What?
Reverse.
What is it?
Now, Lordship, here
Agreement is formed, dated.
agreement is Lordship dated 12/4/06/2000. Then Lordship panelist, if Lordship
Agreement dated
12/4/2006.
Okay. Then
12/4/2006.
according to the
Lordship-
plaintiff, he sent 2 legal notices dated so and so, but the defendant did not reply.
Yes.
The plaintiff on various occasions approached the defendant, but the defendant avoided. Thus, under Article 54, the plaintiff should have filed the suit within 3 years when the defendant refused. There are 2 parts. The first, does the part of limitation start after receipt of the second notice? However, the suit was filed in 2016. Then,
Lordship,
which is much beyond the period, rightly so.
there is a positive evidence regarding a meeting. Lordship, these pleadings are there.
Hmm.
That is not considered by the
No, pleadings are there would not help you. You had noticed categorically. That is why did you issue a legal notice?
to perform their part of the contract, because as per the agreement, there is no time is fixed.
But why did you ask for performance then?
That condition is there. He has
And
to-
did you mention within what time in your legal notice?
No, because agreement itself is there is no time fixed.
In your legal notice, did you mention the what time?
But if there is a condition in the agreement which say that you will obtain the sale permission. After obtaining the sale permission, from the date of that sale permission, within 1 month, we have to pay the balance consideration. Now he did not obtain the sale permission at all.
So if in the agreement it is mentioned that he was required to take the sale permission,
Yes,
what is your notice for?
notice for to execute the sale in terms of the agreement.
So did you give a time?
No,
Why did you issue 2 notice?
we did not give any fixed time. In the meantime, what happened, Lord, they co-purchaser of that land along with the defendant. They have filed suit claiming this right title interest of the suit. So those are pending, and in between, Lordship, we have approached the defendant. There is specific pleading.
Leading on to
We have that he says that let us wait for the outcome of the suit. And both the plaintiff and defendant were they are defendant in those cases, Lord. And both jointly filed written statement in that case. Paragraph 7 and paragraph 8 is our thing is that paragraph 8, Lord, refusal, Lord. Because he denied that he did not receive notice in his evidence. Paragraph 8 at page 21, Lordship. This is our case. That after dismissal of the title appeal number 3 of the 13, at the instance of the defendant, a meeting was held on 19/11/15 at the house of the plaintiff to settle the debt for execution of the sale deed for the suit land. As per the agreement for sale dated 12/4/06, executed by the defendant, but the defendant, in presence of some local people present in the meeting, flatly refused to execute the registered sale of the suit land in favor of the plaintiff without showing any reason thereof, in spite of repeated requests from the plaintiff and other person present in the said meeting. Now, regarding there is a positive.
Who
action.
gave evidence?
The one of the person who is present, he is the PW2. He gave evidence regarding this meeting, and there is nothing has come out in the cross-examination by the other side. And the defendant also have not stated a single date that I refused on such and such date or such matter. He also stated that he also did not serve any notice or whatever to the defendant. So there is a positive evidence regarding.
What is the
this refusal.
defendant's written statement?
Written statement, they have denied everything, Lord.
Very good.
Paragraph 14 onwards, Lordship, they have denied, and there is a contradiction also. Paragraph 14 and 19 regarding execution of sale deed and all. All the evasive denial are there in the written.
Where is your written statement? Show me those, what's called? Where's the agreement for sale? As well as those legal notices. Show me those.
and Lordship, those cases pending subsequent to the fiscal. Pleading are there, Lordship, the evidence are there,
Whether there was any injunction of that.
but there was a status quo order was there. Tell me this, Lordship, that one line is there only that violation of the terms of the agreement. Though it is not very specific. Is para 5 last line, but we have not carried out the state terms and conditions of the state pineapple.
Now kindly see paragraph 7 of this legal notice, which says that kindly do it within 2 days. That is what I said.
Now,
Did he receive the legal notice?
he denied, Lordship, in his evidence that he did not receive the legal. He has denied it. When in the written statement also, he has denied it. But Lordship, so
Here you have given on 4 days.
that is
These
there,
are
Lordship,
legal
but-
notice of 4 days.
But subsequently, Lordship,
Subsequent,
subsequent-
they cannot. You see, this incident happened in 2015. The subsequent events which you are saying happened in 2015.
yes,
Now, the period of limitation in terms of 54, there are two first. Article 54.
yes.
First is the date fixed
Yes.
or when he has notice.
Refused.
Now, when he has noticed that the defendant is refused, there is a case where you asked him, kindly do it within 2 days. Or you have again asked him, kindly do it within 4 days. Now, if it is not done, you have the area of refusal. Now, this happened in 2010. The next event happened in 2015. In the meantime, 3 years is over.
During that period, Lordship, these cases are going on. There is status quo order is
Oh.
also there. And Lordship,
Did he say anywhere that because of the status quo order, we could not?
no, it is stated by the defendant, Lordship. Now, Lordship,
Bad case.
Lordship,
Limitation, good ground.
no, that refusal, Lordship, is not a refusal, Lordship.
This is refusal.
But
When you ask for to do a particular thing, you see the judgment in Fatehchan. It categorically says that if there is a requirement of taking a permission, the fact that he has not applied the permission within that particular period time is itself a notice to the effect that he has not done it.
But-
And as such, under Order 7, Rule 11, the plaint was illegal.
no, but he is said in the category that it is not received by him. And he did not say any evidence that he refused at any point of time. After the evidence part, Lordship, that has to be seen.
Why should I see it? There another court who will see it.
Lordship, kindly give me some time to.
Yeah, time is given. This is not a fixed case. Judgment rightly. So, at the request of Mr. Jish, Dekam matters adjourned to be listed again on 10th of June. I want.
Oblige.
Yes, what is this?
My prayer for amendment of the rejected.
Amendment was rejected. Amendment of what state?
The phase of evidence of PW, plaintiff evidence.
You are defendant.
And the two witnesses to be filed. They are yet to be perfect.
What you wanted to amend?
In the petition, Lordship, the annexures are not visible, Lordship.
Huh?
They petition, Lordship, annexures are not visible. I have filed an additional evidence, a type of.
No, what you wanted to amend?
Additional fact in addition to the fact already mentioned in the
What is this counterclaim?
claim has been just added lordship as counter, it should be treated as counter. It is not maintenance, it is not properly subject. Some additional fact.
Plaintiff have given evidence. Huh?
They are yet to be cross-examined.
Understood. So now you will have to again change. Issues have to be framed. Then who is going to pay his expenses? How much did you charge? How much was the expenses for making those two evidence on affidavit? 25,000 each must be.
Actually, the amendment is not, the amendment itself is not maintainable because the hearing has already been started. And my lord, the case 39, your lordship can see description of the proposed amendment. In the cost title
And counterclaim.
and counterclaim.
What is this counterclaim business?
It has been not been properly subject.
But neither Dhupri Law College nor Adhiraj Chaudhary had ever possessed the same on the basis of the state so-called sale. Earlier, did he agree? Is this an admission, taking away of an admission?
No, no. Actually, the predecessor of the defendant and his brother purchased the plot of land.
No, this amendment cannot be allowed. How can you? And you have not put it in paragraph. How can I segregate? Tell me.
Has to be properly subject. The amendment itself has to be properly subject.
Because this counterclaim business, you couldn't have done it.
The framing of issue does not affect.
Hmm?
The framing of does not affect.
Can be done, but the fact that only thing is will be subject to cost. Can be done because if you see the recent judgment, I think what is the name? Sikandarabad or something. Isn't it? And there is another judgment later on, judgment by Justice Partiwala. Another judgment. So in these two judgments, if you find has been given in detail what are the parameters to be followed. This can be permissible, but the thing is not in this time. So for this court, then to allow this amendment, one has to say that this portion to this portion cannot be allowed.
It is very complicated.
Not the manner this court is going.
Very complicated.
What is this amendment for? Why you wanted this amendment?
If earlier some other advocate was engaged, he died. That means that during cross-examination,
During
the cross-examination
of
the plaintiff evidence, they think that amendment should be deferred.
it can rejected. Right. But did you mention anything about the compromise petition?
In the obvious not.
It is already mentioned in the plain.
Mentioned in the plain.
So you can very well give your evidence. Why do you need it? Your main thing is about the compromise petition, signing and all. This is kindly see at page 49. Now the remaining amendments against the present more details of so and so, but the plaintiffs have already mentioned about the previous case involving the parties and compromise petition in the so and so, and defendants have also mentioned in the return, and they were not aware of filing of the demand and any compromise petition. So you have already mentioned. It is only the question of amplifying it. You can very well give it by way of evidence. I don't think anything here. Withdraw, dismiss, which one? Huh? Hello. This is an application filed under Article 227 of the Constitution, challenging the order dated 12/9/2022, passed in Mise case number 57/2021, arising out of title suit number 49/2017, whereby the learned court of the civil judge Dhubri had rejected the application filed under Order 6 Rule 17 of the Code of Civil Procedure 1908 for amending the written statement. This court have taken note of the amendment application, and from a perusal of the amendment application, have taken note of the amendment application. In addition to that, this court have also taken note of that the said amendment application was filed at the stage after partly cross-examining the plaintiff witness.
We have filed our evidence and affidavit. We are not cross-examined.
And at the time after the filing of the evidence on affidavit after the filing of the evidence on affidavit by the plaintiffs, from a perusal of the said amendment application, it is seen from a perusal of the amendment application as well as the impugned order, it is seen that there is no mention as to why the petitioners herein, where the defendants, could not file the said amendment application earlier. There is no mention also, no aspect pertaining to due diligence have also been taken care of. This aspect of the matter has been rightly taken note of by the learned trial court in passing the impugned order. Mr. Kulta, you withdraw. The reason why I'm saying is the moment I say all these things, it will have a far-reaching consequences later on. You may not be able to say anything. You withdraw. Mr. D.K. Kulta, the learned counsel appearing on behalf of the petitioner, submits that he may be permitted to withdraw the instant application. And application. And the withdrawal of the instant application should not prejudice the case of the plaintiff, of the petitioners in the trial court. Taking into account the above, the instant application stands closed on withdrawal. The interim order passed on 12/12/2022, whereby the further proceedings of title suit number 85/2021 pending in the court of the learned Munsif number 1 Dhubri, which was stayed, is vacated, and the parties who are duly represented are directed to appear before the learned trial court on 24th of June 2020. Because if I reject it, you can't tomorrow raise 105. That is why I think. Yes, Mr. Sharma.
Already here in this case, we have challenged the order passed by the Learned Lower Appellate Court. The facts of the case is this, madam. The petitioner has identified a suit for partition
of the property. The decree was dispute was decreed. Thereafter, the defendant preferred an appeal. In the appeal, the argument of both sides were heard, and it was fixed for judgment. On the date of judgment, the landlord appellate court passed this order. The page 67.
Page
67. 67.
67.
Last.
Learned advocate for both sides while writing that it appears that the substantial cause for substantial evidence of the iman is necessary, being additional evidence to decide the appeal effective. Hence, in exercise, this appeal is posted for recording of evidence of iman. So the judgment could not be delivered. It is heard. Was there an application under Order
No.
41 Rule 27?
No, neither appellate nor the respondent filed the application. The court so moto is passed this. Whether the court can pass so moto order,
Any?
any other order 41.
Can the sumoto pass it?
Yes.
The parties to an appeal shall not be entitled to produce whether oral or documentary in the appeal, but if does it restrict? Does it restrict the appellate court to ask for?
Yes, my lord, the additional evidence on the ground that some additional document, additional facts found by the parties, then they prayed for the additional evidence. The court cannot pass that order because when the parties
Where is the other side?
other statement that the notice was issued and the notice is delivered by our ordinary post.
Service is not complete. No. Service not complete. Service being not complete leaves the matter again on 22nd of July 2024. The petitioner herein is directed to take fresh steps upon the respondent herein by way of registered as well usual within 3 days. Interim order passed earlier shall continue till then. I think, Mr. Sharma, it can be done. The order can be passed. The court can direct that I require some evidence. Me direct. But he has to record better reasons.
Yes.
But nothing is given. He cannot say that I want evidence.
On what point?
What point and what is the basis?
What is the?
I think that is why the order is bad. But you can't say that the court doesn't have the. Tomorrow, just for example, the court wants the particular document has not been properly, because the court also have the power under section 73, just for example, to or look into the expert evidence or anything that he wants. The court, the first appellate court can do so. And in that regard, may direct. But to say that the appellate court does not have the power will be, I think, much. Being the last court of facts.
That may be, but under this
But
case,
this order is bad.
Here the respondent number 2, 3, 4.
Yes, eh? Notun case. Item number 37, 39, 40, 41, 42, 43, 44, 45. All issue notice returnable by 6 weeks, except within 3 weeks. Now, yes, coming to your.
In this matter, respondent number 2, 3, 4 have died not long back. They
Then-
were the pro forma dependent in the
They were performer.
Yes.
2, 3, 4.
name is
Mr. S. Biswas, the learned counsel appearing on behalf of the respondent, appellant submits that the respondent number 2, 3, and 4 are performer defendants and a performer respondent. And as such, their name, and as such, although they have expired, there is no necessity for substitution. Their name may be struck off. Taking into account the above, the names of the respondent numbers 2, 3, and 4 are struck off. This court have also taken note of that the service upon respondent number 1 is complete. Accordingly, and the LCR has been received. Accordingly, the appeal for hearing in its usual course. The counsel for the appellant is directed to file a fresh memo of parties before the registry on the basis of the instant order, as well as also that the name of the respondent number 5 have also been struck off, and the registry shall make necessary correction of the record as well as also update in the CIS.
Much pleasure.
Respondent number 5 expired matter. You have filed a subsequent petition.
They have filed.
Today,
Mr. V.K. Borua, appearing on behalf of the appellant, submits that a substitution application has been filed in respect of the respondent number 5. However, the same is not on record. To list the matter after 2 weeks along with the said application. Service complete. Service complete. A. What is AA? 1A.
the sole respondent died.
Is 2. Yeah. Okay. 1E complete. Service complete. LCR received. Service. This is an IA for what?
IA for substitution application.
It has been done.
What?
And already been disposed of.
Already been disposed.
Taking into account that the service is complete, list the matter for hearing in its usual course.
Long pending 2008 final.
So that is why it will come. Usual course means obviously it will come. Liberty, however, is given to the appellant to file the parties to file appropriate application for early hearing. Okay.
The service is complete.
Service complete.
1, 4, 1, 2, 3, 4, 5, 6, and 8. And my lord, in the
No steps have been received in respect of respondent number 7, perform respondent number 9 to 13.
my lord, my submission affidavit is a very poor part. My lord, in respect of performer respondent number 9 to 13, I am allowed to take usual.
What was the earlier it was given?
Earlier it was both registered and I have taken my lord for 1, 2, 3, 4, 5, and 6, and 8.
Appellant is very
Very poor, my lord. This is mentioned in the plain.
heard Mr. Teacher Chaudhary the particular was decided.
It is my only the limitation.
You are appearing? Mr. Counsel, you are appearing?
I am appearing for lordship respondent number 1, 4, and 5.
1,
1, 2, 3, and 4. 1, 4, and 5. Sorry.
1, 4, and 5. What about 2?
I'm
2
not
served. 3 served. 4, sir, 4 he is appearing. 5 he is appearing. 6 is Latu, Mujit. What is this? 6 is wife received. Wife received. Service complete. 8, 7, 8. Service done.
7 is not done.
No, no, it's state of Assam. It is done.
8 done.
9, 10, these are performer.
Performer.
We do one thing, we check up their name. Not necessary.
Here.
Okay. Name. Taking into account the above, taking into account the office note dated 25/2024, which shows that the service upon the respondent number, taking note of the respondent office note dated 25/2024, as well as Mr. R.A. Chaudhary, the learned counsel appearing on behalf of the appellant. Who appears on behalf of the respondent numbers 1,
4 and 5.
say 4 and
5.
1, 4 and 5. The service upon the respondent numbers 1 to 8 are duly complete. Mr. Swayam, HR Chaudhary, the learned counsel appearing on behalf of the appellant for the submit to the names of the respondent number 9 to 13 may be struck off, taking into account that they are performer respondents oblique defendants who never contested the appeal, the suit as well as the first appeal proceeding.
No, my lord, they contested.
Then why you are making performer?
Because it was made as a performer in the plaintiff and in the appeal.
Who is the plaintiff?
Plaintiff is me, my.
So he's in your, they are in your favor.
They are not my paper.
Then why are you making them performer?
Because they were made performer in the plaintiff suit also and the appeal.
Understood. Didn't you mention that if a performer out there goes against you, did you seek any relief against them?
No, my.
Did not seek any relief against. Taking into account that the respondent numbers 9 to 13 are performer respondents, the names of the say performer respondents are struck off. List the appeal for final disposal for hearing on 27/5/2024.
Okay.
At the top of the list. At the top of the list for it. We'll dispose it of on that day.
Okay.
It's a very petty thing. The Supreme Court order not to have been taken into account. Today I don't have the time.
It was not pleaded.
Huh?
That part is not pleaded.
Does he have to plead? For a judicial officer not to know that limitation, there was no limitation from 15/3/2020 to 10 to 2010, 28 to 2022.
28 to 2022.
There was no limitation and he dismissed it.
Only.
On 27 for on 25. 27. 27/5/2024 at the top of it. Dispose it on that day, huh?
Obliged.
20? Yes, what is this?
Lordship.
Oh, appeal.
Lordship.
LCR has been received, LCR TS not received. Taking into account the office note dated 25/2024, the registry is directed to forthwith take appropriate steps for requisitioning of TS number 38/2009 from the concerned court and thereupon to list the matter for hearing in its usual course.
Lordship, I have received the notice without a copy of the petition.
We'll give it. Good friend.
My lord, will see the office note dated
26.
31/24, my lord.
You are appearing for?
I responded, but
Where is the petitioner?
petitioner is absolutely the earlier council has withdrawn, my lord.
Counsel for has withdrawn the vocal and therefore notice be issued, but notice is yet to be served.
31/2024 may be seen, my lord. Office
Eh?
note. Office note dated 31/2024.
Yes, Mitro. Why? What has happened?
But he is the tenant, my lord, who has filed this revision petition, my lord, and the order frame.
We do one thing. None has appeared on behalf of the petitioner on call. Mr. J. Roy, Learned Senior Counsel, appearing on behalf of the respondents, who's taking into account for the end of justice, the matter stands adjourned to be listed again on 17th of 19th of July 2024. The interim order passed on 3/5/2023.
So that order is, that interim order is, my lord, already is vacated. That his own admission at page 17, my lord. Para 18. Because before, my lord, he got a stay, he's been evicted, my lord, by execution proceeding.
He has been evicted.
Evicted. That's why he's not coming to the court also, my lord.
Okay.
He has to pay 6
Honorable.
lakhs.
None has appeared on behalf of the petitioner on call. Mr. J. Roy, the learned counsel, senior counsel, appearing on behalf of the respondent, submits that pursuant to the vacation of the order, interim order on 31/7/2023, 31/7/2023, the execution in the execution proceeding, that is title execution case number 38/2022, the petitioner herein have already been evicted.
Evicted on 12/4/2023.
On 12/4/2012?
12/4/2024.
How is it possible? When there was a stay?
No, stay.
Oh, okay.
No.
None appears on behalf of the petitioner on call. The learned senior counsel, Mr. J. Roy, appearing on behalf of the respondent, submits that on 12/4/2023, in title execution case number 38/2022, the petitioner have already been evicted. He further submits that the instant proceedings thereafter though filed and there was an interim order passed, but the same was vacated. It is under such circumstances that the petitioner seems to be Under such circumstances, it seems that the petitioner is not interested in the instant proceedings. Accordingly, the instant petition stands dismissed for non-prosecution. Service complete?
Service is complete, already appeared.
Okay. What is there? There is a stay?
Still.
Okay, we'll have it on some other day.
Monday.
No Monday on the business. List the matter on 10th of June 2024.
Correct.
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 There's a stay, na?
Yes.
Till today?
Yeah, that has to be.
Till 10th of June, interim order passed earlier shall continue till the next.
This CRPIO is filed by the petitioner for filing of the written statement to grant her adequate time. And the last date court is asked for the status code of the status of report.
Because you want to file written statement?
Yes.
Why was the written statement not allowed?
Because the petitioner has received the summons lately, and according to the petitioner, already 90 days have been passed. So they are stating that now you cannot file it. The court is also denying. But petitioner has
There's
not
no
received-
interim order, na? There's an interim order.
No.
Today we don't have the time, madam. When is the next date fixed?
6/6.
Let's try on 31st. Service is complete.
Yes, sir.
List the matter on 31/5/2024 at the admission.
Let's try, my lord.
Hmm.
This was dated 22/9/23. So that my lord did notice upon the response number 2 was served upon her nephew, ma'am. There is
You're from,
For one, my.
oh, who is two? You want to take fresh steps? Mister? The counsel appearing on behalf of the applicant submits that he want to take fresh steps upon the response number 2. He is directed to take fresh steps by way of registered as well as usual within 7 days.
Hello.
Service not complete, list the matter after completion of service.
Lordship, I am for respondent number 3.
Very well. 2 is not there. What is this I for? I for?
28 days delay in filing application. 28 days.
Lordship, two objections are there, Your Honor.
What?
Objection is there.
Objection?
Condonation of
That
delay.
is you heard, this is not at all environment fire friendly. Don't spoil papers on these things. 28 days delay, we consider it some other good grounds for that. Delay of 28 days condone. Accompanying RS to be registered and listed for in the stage of order 41 on 10th of June. On 10th of June, fight with all vigor against Mr. Gusukh.
Objection.
Give your names, huh? Yeah.
My lord, long limitation, my lord, but my only prayer before your lordship, my case is not decided on merit and at any stage. Only because of this limitation every time it is. So, my lord,
How much?
My lord, it is 1192.
1192.
But during COVID period, my lord, some concession is there. But
715 days.
that is one year, my lord.
715 days.
Yes. So
Did you
that-
get it?
that-
And after getting it also 1192. Without that.
Including that.
So it will be around 400 days.
Yes.
Yes. What do you say? How much is the delay? It will be
1158 days, my lord, before lockdown.
Your lordship will turn to page 5, para 2.
1263 days.
It is pertinent to mention here that as per Supreme Court decision, limitation does not run with effect from 15/3/2020 to 28/2020. Well,
Your delay is 1263 days without considering, after considering Supreme Court order.
my lord, my humble submission before your lordship. Suit was for cash possession, right title and declaration, but it is not decided on merit. May I pray before your lordship by imposing some cost, my lord. I am not going on merit of this statement. But my prayer before your lordship, let my cause be decided on merit. Because I purchased the land. It was encroached by the defendant. Because my lord, in civil suit, act by the order was passed. And thereafter appeal was filed, that was barred by limitation. So that was not allowed. Ultimately, my lord, my cause is not decided by the court. I am deprived of my substantial justice, my lord, for the cause of the case. Throughout the process. I am ready to pay some cost.
You are saying you are ready to pay the cost, and on paragraph number 3, your entire edifice of your case is you don't have money.
some cause is to be given, but my humble
Mr.
submission-
Sheikh, after saying yesterday that this is a court who only imposes cost, the justice is
That was
only
my
cost.
submission.
Yesterday, after saying all these things, and today you want that I should impose a cost, and that too after stating that we are poor laborers, we don't have money, and then also we are only having some money for our square meal, and you are on one hand asking that this court should impose cost.
But because my lord, my cause is not decided by any court. That was my statement. regarding voting period as well.
Mr. Sheikh,
My lord.
your case is for what?
Truth.
Petitioner earlier filed IA so-and-so under Section 5 in the Honorable High Court in connection with aforesaid RSA. The said IA was dismissed on withdrawal.
My lord,
Why?
I withdrawn, my lord, because my lord, proper information was not given to me.
What information have you put here?
My lord.
There's nothing. You have to say,
No,
when
I
did you
have
come to
stated-
know about the order?
I have stated in the earlier petition regarding my economic condition. my lord.
Mr. Sheikh, kindly say, don't you have to say, when did you come to know about the order? Have you mentioned a single word in this application, 1900? Is he mentioned?
19
That is my lord,
yes,
why it was withdrawn, my lord. When I come up with an affidavit in opposition, my lord, saying that petitioner number 2 is the GOPT employee, then my lord, all petitioners were to be stated in this petition. When I came up with affidavit in opposition saying that petitioner number 2 is a government employee, my lord, then it was withdrawn. Financially sound, my lord, and all having, my lord, landed property.
They're financially sound.
Financially sound.
No, my lord, financial
Financially
sound is,
sound.
my lord, only one person, my lord. I have stated specifically in para 3, my lord. Only one person government employee.
Hello? You
Other
say
hands-
that you are poor, file your affidavit of assets. File your affidavit of assets.
No, my lord.
File an affidavit of assets, we sign.
And
If
now
you file it false, you know the consequence which will happen.
Here I have not falsified, my lord. Your lordship would be pleased
Huh?
to see. In para 3, in this present
In
petition,
para 3, except petitioner number 2, all are poor.
all are poor, my lord. It is,
So
it is-
file an affidavit of assets of the
my
other
lord,
poor.
it is correct statement that is not denied by them. Only thing was that they have filed an
You are saying that others are well.
opposition, my lord.
and my lord, wife of the petitioner number 5 is the
earlier
Anganwadi
petition.
worker. And petitioner number 4, my lord, he is having big shop, my lord, grocery shop. Apart from having landed properties.
My lord,
In his name.
Yes, my lord. And I have annexed one, my lord, Jamabandi copy, and other Jamabandi copies are here, my lord. Oh, their names, my lord, reflected in this Jamabandi, my lord.
Where is
Having
it?
landed properties.
Yes.
In my affidavit in opposition, my lord.
My goodness, a strong affidavit.
my lord, one government employee, my lord. Landed property, I have not denied
Opponent
that I do
declares
not have
petitioner
landed
number
property.
2, Abu Tahir, is a government employee who is a school teacher at Swen.
Grocery shop is there.
The petitioner number 2 is getting handsome salary, and during the period of lockdown, his salary was
LP school
continued.
teacher, my lord, handsome salary.
Moreover, petitioner number 4 has a grocery shop in his
Grocery
local
shop.
market.
Yes, my lord, grocery shop.
Why do you say you are daily laborers? You said you are daily laborers.
Para 3, my lord.
There are 3.
Yes, my lord.
1, 3, 4, 5, 6, and 7 are daily wage labor.
My lord, this
And now you are saying grocery shop.
no, my lord, grocery shop is small shop, my lord. That is not the subsistence to me, my lord. That is not the subsistence. I am to go for labor also sometimes.
Wife of the petitioner number 5 is working
in
as an
Jammu,
Anganwadi in local Anganwadi center and getting salary including other facility from Government of India. Also stated that the other petitioners or other various income sources including culture, cultivated land, fishery, etc. are nowhere poor people. There are 2 plots of land covered by dark numbers so and so, so and so. You file your reply, Mr. Sheikh. And first of all, your application has to be, I would otherwise dismiss it on the ground that you have not mentioned how did it, when did you come to know? There's nothing mentioned. You say I'm a poor man.
No, my lord. Why I come to know? Because, my lord, every time I am before the court,
Isn't it required for you to state in your petition?
order is passed in my presence, my lord. All order. So, my lord, regarding information, possibly, my lord, your lordship pointed out, all right, but not necessary because not that.
So we will construe that you knew about the order, but you did not file on account of lack of,
That has been stated.
only on the ground that you had no money.
I have no money and during COVID situation, my lord, you're not.
COVID came later on. You were supposed to file in 2016 and COVID came in 2020.
That I have explained, my lord, your lordship.
I'm not concerned and later on. 2016 you had to
My
file.
lord, 2016, all right, my lord. What happened, my lord?
But
I was-
Mr.
I
Sheikh,
was
with
to
the affidavit filed by them, if you don't file a reply, you don't have a case.
I will file reply. I will file reply.
And you want this court to impose costs. I have finally
My
thought
lord, your
that,
lordship
okay,
will-
after what
My lord,
Mr. Sheikh has said, I won't impose any further cost upon the opposition party of Mr. Sheikh whenever he is otherwise entitled. Just for example, if he was the appellant and his appeal is dismissed, I normally would have imposed cost. But if I would have, but if you are there on the other side, I would not.
my saying was this, my lord, that as a whole, my lord, cost
Hello.
should not be.
Mr. M.A. Sheikh, the learned counsel
Analyzed.
appearing on behalf of the petitioner, applicant submits that he would like to file a reply to the affidavit in opposition. List the matter when?
After 2 weeks, my lord.
Okay. List the matter after fix a date? Yes. On 14th of June. 14th of June. So the affidavit in reply be filed by 11th of June.
My lord, with humble submission, my lord, that was my general submission before your lordship regarding this.
And
condition
today
of
you
the
are
application.
asking for this court to impose cost.
My lord,
And after saying that you are so poor,
my lord, my cause is not decided by the court. My cause is not decided by any
can't help it. Can't help it. You can't. These what to
Let me
do
file
nowadays.
reply, my lord. In that case also, I will agree to pay cost for that. After reply. Oblige, lord.
Yes, what is this I for?
I have instructions to withdraw the matter.
Which one?
33 laws.
This one?
Yes, sir.
I.
I am
I for what?
for delay conduct.
For delay. Okay. Mr.
Didas.
Didas, appearing on behalf of the applicant, submits that the Assam State Transport Corporation does not wish to press the instant application which was filed for condoning the delay of 1197 days in preparing the accompanying appeal against the judgment and order dated 28/6/2017 passed by the learned member Motor Accidents Claims Tribunal Nagaon in MAC case number 2372/2015. Taking into account the above, the instant application stands dismissed on withdrawal. The consequential effect of the dismissal of the instant application is that the accompanying appeal filed against the judgment and order dated 28/6/2017 in MAC case number 372/2015 by the member Motor Accidents Claims Tribunal Nagaon cannot be entertained, being barred by limitation.
Matter has already been settled.
Whatever may be, I have to say because otherwise these papers will remain. Can't help it. Yes, what is this?
392 days delay in preparing the reply second.
Why there are two? So many IAs were.
Lordship counter claims also there for two regular second.
These are counterclaims you have filed.
Counterclaim and suit, Lordship. My suit was counterclaim was 50. Counterclaim was for recovered the post. So I have filed two RS along with two RS, two control.
Two RSs you have filed. Okay, both are 392 days.
One is 392, one is 360. One have filed.
You are opposing?
My lord, yes, my lord. I am opposing because the grounds shown by my learned friend, my lord, at page 5, your lordship may please to go through it. Because all bogus ground that they were under the impression that they had lost in the trial court. So they were under the impression they will be protected by the appellate court. That is the grounds he has taken, my lord. And
my suit was dismissed, Lordship. So
and second ground, my lord, that is more than funny.
No.
Second ground.
Yes. At the end of the day, something funny is there.
Yes, under the impression they had no money. And thirdly, my lord,
This
regarding
is a very new thing. No money.
no money. And regarding illness, my lord, there is no medical certificate, nothing, my lord. It's a bogus explanation, my lord. And I have taken possession, my lord. Execution case is closed, my lord. I have taken possession, my lord, long ago.
Okay. You filed your reply.
Yes, my lord, I have filed it.
Hello, we'll have it some other day. Okay, list the matter. When? Urgency?
already I am for the Lordship there for already Lordship because there for
In December October 2023, I got possession.
List the matter again on 19th of June.
I accept, my lord. 18th and 19th June. I will be out of station, my
June.
My lord.
June, you are not there.
Only in the middle portion, my lord. From 15th, I will be out, my lord.
Interesting. So we'll have it in the month of July.
That
You will
do,
be
my
back.
lord. That will do, my lord.
24th June. Okay, 24th June.
Yes, my lord.
Okay. But Lordship, we have filed one IA for injunction. They are required to file affidavit in opposition.
My lord, the thing is that once a petition was filed, IA, that is 1595, 2022, that has been withdrawn. But this petition again filed, but no copy is furnished to.
Without copy,
I don't know. I have not received any copy.
Already it was listed and they sought for time for filing affidavit in opposition.
That affidavit is already filed in the earlier case.
No, on
1595 is already withdrawn.
Who is Bulbuli Devi? Bulbul Devi.
Hello?
Bulbul Devi.
Bulbul Devi is not.
Bulbul Deka.
Bulbul Deka is Mohori one.
Your person.
No, not actually my person. He is Mohori.
He has received it on 38.
He has not given me. He has not given me.
I can forward. I
He
can
has not
forward
given me.
another copy.
He is a Mohori, I know him.
And on 29/9/2023,
But on 29/9/2023, somebody appeared
My lord, that is in
by
the impression that
DDB.
1595. That was 159.
No, 2685.
Yes, my lord. My
Somebody
junior-
appeared, Miss D. Devi appeared
Yes, my junior.
and
No,
sought
no,
for time to file affidavit.
my lord.
And it was directed that till the next date of listing, no construction work shall be taken in respect of Sudul.
She was not aware about this case, my lord. Once it was withdrawn, my lord.
Anyways, do one thing. You give up a copy. Okay. When do you want it? How much time you want to file?
My lord, 15 days.
Hello. Mr. DCC Pukon, the Learned Counsel, appearing on behalf of the respondent, seeks for a further accommodation of 15 days for filing a reply to the instant application, seeking injunction. We'll list the matter again on 21st of June. In the meantime, the reply be filed by 18th of June. Interim order passed earlier on 29/9/2023 shall continue till the next day.
Okay.
Oh, Oh, this matter. Yes. 10 minutes time you have got.
Your Lordship, the impugn order is at page 63. In terms of the amended provision, Your Lordship may see their petition. Their petition is at page 85. No ground, nothing has been assigned. No ground under 36(3) also assigned. Only for the aims of justice, the operation. And the learned court below.
No, arbitration case is not state.
No, arbitration case is not
34
state.
is not state. Till returnable date, the operation of the impugn order dated so-and-so past in so-and-so is.
34 is not state.
Now what to do?
Your Lordship, this order.
You and the property names of ONGC, you have the property's name. Attach it.
Execution we have already.
Attach the ONGC building. You have a building. ONGC has a building in Guwahati.
I have taken instructions. I have called people. They are saying, subject to what Lordship, we are willing to deposit 100% bank guarantee against the arbiter. That suffices.
Huh?
If that suffices for the state to operate.
No.
No, the storm amount.
You deposit how much it is there. You do, that is your lookout.
100% of the arbitral award.
Arbitral amount you deposit, 60% he take.
Subject to them furnishing a security method, because that is the mandate of the Supreme Court judgment.
What does it say?
It says, if I just read it, there shall be interim stay of the award subject to the petitioners depositing 60% of the amount of the decree. The remaining 40% amount shall be secured by way of bank guarantees of a nationalized bank within 8 weeks. The respondent shall be at liberty to withdraw the said amount on furnishing appropriate security.
Appropriate security they will give. They will give a what? What security they will give?
Because they're a private entity at the end of the day. If they go into liquidation or if something of that sort happens,
and they will
we'll have to protect our
amount, whichever that the executing court will know.
That only that of the.
So why don't you give that? That the 60% you agree to this, and in terms with this order you are going to pay. Matter over.
Deposit of the money amount is difficult. I'm saying 100% bank guarantee through a bank guarantee.
No. Why don't you take the bank guarantee of the not bad. Take the condition to that effect. Take that condition, but you see, if it is a bank guarantee, no, is there any interest given?
Interest is given to me, 12%.
If the interest is given, the interest gets go. You give because the bank guarantee is no interest.
No,
it will keep accruing.
So
no, my only thing, if some money comes, I can utilize it. With that. But
60%. You agree to that condition as per that order?
They'll have to furnish some security then. That security.
They will give you security to the satisfaction of the authority. The satisfaction of the court. Not to the satisfaction. This same order would be passed.
I'll leave it to my lord. Only that my contention, if my lord records, that they 100% bank guarantee of the entire article.
100% bank guarantee, we are not agreed.
My lord may just record my subject.
Then we won't go into all these things. We say this order is bad. Whatever you like. Where's that order?
It's 83
is the order.
Okay. This is an application under Article 227 of the Constitution challenging the order dated 13/12/2023 passed in Misal case number 1/2023, whereby the learned court of the district judge, which one? District judge where?
Chiptagar.
Had paid an arbitral award in arbitration case number 02/2021 dated 21/6/2023 without following the mandate as stipulated in section 36 of the Arbitration and Conciliation Act 1996, taking into account that the said order on the face of it not only is in violation to the order to the statutory mandate of section 36 of the said act, but also is devoid of any reasons for which the order dated 13/12/2023 passed in Miss R case number 1/2023 stands set aside and quashed. Problem which will happen now is you have to file a fresh application, or there is no application now.
Yes, no, it will be,
Then
called-
the observation that we'll be at liberty to file a fresh application.
No. You file an I, you didn't file. Why should I? How can I give an observation? Your
They
entire
won't- what-
application goes. Do you know that?
I'm submitting.
And then you have to again come to the High Court. You can't go there. Against this, you have to only go to Supreme Court.
Supreme Court.
There's no way.
Because we are saying that we'll deposit the amount. Only thing that I'm
That
saying
why
for my
should I? I only gave you that idea of 60/40.
yes, my lord,
That is
subject to them furnishing the security, my lord.
That is what you agree to that. I'm willing to 6 weeks. I'm giving you to deposit. I'll continue to pay.
And my lord, only for my limited prayer, my lord, that my submission may be recorded, and I'm willing, bowing down to what.
Which one?
that
100%.
100%.
No. You agree to 60/40. Then only.
But I cannot.
Otherwise, there is no. Otherwise,
I
this
leave
order
it,
is
my lord.
bad.
My lord may pass that order. That part 60/40 order.
This is only the thing. 60/40, if you are agreeable, that is why I can draw the earlier order. Because that is the Supreme Court judgment. You see, there are two judgments of the Supreme Court in that case. The first judgment is 60/40, the second is 100.
Later, my lord, in Naira Energy was reduced to 75. That three judges.
75 is what?
75% cash deposit, 25. But that is not with regard to an arbitration. But it had reference to pay.
So do you go by 60/40?
I leave it to my lord.
This is an application under Article 2 to 7 of the Constitution challenging the order dated 13/12/2023 passed in Mr. case number 1/2023, whereby the learned court of the additional district judge, Shivsagar, had in exercise of the powers under section 36 of the Arbitration and Conciliation Act 1996 state the entire arbitral award without even taking record, without taking note of the legislative mandate as stipulated in section 36 of the said act. This court, by an order dated 17/5/2024, had asked Mr. B. Chaudhary, the learned counsel appearing on behalf of the ONGC, as to whether the respondent herein would be ready to pay 60% of the decretal amount and the remaining 40% by way of bank guarantee. The learned counsel submits on instructions that the respondent herein would be ready to pay the 60% of the decretal amount and 40% by way of bank guarantee. He further submits that the said 60% of the decretal amount can only may be released to the petitioner herein subject to furnishing proper security. Taking into account the above, he further submits that the said amount shall be deposited within 4 weeks.
It could be 6 weeks.
What?
6 weeks, man. 6 weeks.
No. ONGC big.
Because my
4
lord,
weeks.
because we'll
This matter going on for a long time.
my lord, I'll be back again praying for a direction. My lord. 6 weeks, let me 6 weeks.
The said submits that the said amount would be deposited before the learned executing court by 24th of June 2024. Along with the said amount would be he submits that the respondent ONC would be in a position to furnish the said amounts by 24th of June 2024. So, taking into account the said submission, this court continues the stay so granted in the order dated 13/12/2023 in Miss R case number 1/2023, subject to the petitioner, the respondent here, ONGC, depositing an amount of rupees, 60% of the arbitral award before the registry, before the district judge, before the depositing, before the learned executing court, and the remaining 40% of the arbitral award be deposited by way of bank guarantee, with a specific condition that in the circumstance the said proceedings under section 34 is decided against the respondent ONGC, the said amount shall be, I shall submit the bank guarantee. Full stop. By 24th of June. Full stop. It is further made clear that if the amount is deposited, it's made clear that upon the said amount of 60% being deposited, the petitioner herein would be entitled to release of the said amount, subject to furnishing due security to the satisfaction of the executive. With the above, the instant
failure to adhere to this order, the state that has been granted may be vacated. That line.
It is made clear that if the order, if the direction that the instant order is being passed on the basis of the instructions and the undertaking so given, failure to deposit the said amount would not only amount to violation, not only amount to violation of the order, not only amount to vacation of the interim order, the vacation of the stay to the arbitral award, but would also amount to violating an undertaking given before this court. So for that you can take the contempt is also.
That will be accepted.
Eh?
I've received the instruction on.
Tell you,